Hey all, here is a replay version of the most recent live stream Q&A on all things Social Security that occurs every Wednesday at 1 p.m. Eastern Standard Time. So this is with all the little silences carved out of it. So I hope it's an easier listen for those who are doing the replay versus being there live. And we'd love to see you live. So feel free to pop in. Bye-bye now. Hey guys, how is everybody? Shiloh, I see you are here bright and early with 5 million questions. We'll see. We'll get through them, but we'll probably jump around because I don't want to make everyone else not be heard. Are you? Dimple's in the house. Dimple says yes, she can hear us. Okay, good. Guys, you know Shana Justice of Justice Disability. Shana's in Kentucky, right? And Shana, do you see the postings part?
The comments, yeah, I see them.
Yeah. I mean, if you want to put your website in there, so if anyone wanted to reach out to you, feel free. You know, you could just type it right in there. It'll come up on the paste. Do you see what I'm saying?
Yeah, it'll let me.
Okay. Anyway, so Shana's been here before a couple times. So we're gonna share your questions, and you can see maybe a couple different perspectives and stuff like that. I see Shiloh's in the house. Shiloh's become a regular, Shana. Kevin Johnson's in the house. Kevin Johnson's a regular. He actually prevailed, so he comes back and says hi. And no, I wasn't his representative. But everyone loves you. Thomas Harris is in the house. Always good to see you, Thomas. Dimple, of course. Awesome. Kubi Dreams was here last week and is back again. Nice to see you, Kubi. Do you see the same scroll I see, or you have a different scroll, right?
I think I can see what you're seeing, all the comments. Yeah.
Yeah, and I'm scrolling. I don't know if you can see that because I think you can.
No, I can't see yourself. Yeah, I can do it for myself.
Okay. Earth 1 is in the house. Earth 1's been here before. Nice to see you. All right, so let's go back up to the start. I'm going to start with Shiloh. Again, I'm going to probably, Shiloh, depending on how that rolls, because I know you got a lot of, it looks like maybe function report questions. Yep. I don't want to use the whole 2 hours for that because I don't think it would be fair, but we'll try to hit on some and in a way that, you know, would be helpful to other people. I also wanted to add, guys, we just got the waterfall chart for 2025. And I'm going to probably do a video on it because I think it's just important to know. And by way of explanation, the waterfall chart, it's put out by the SSA information, and it shows you how, because people are always asking, how many people win, it's very broad though, win on initial, and how many are denied. And that encompasses everyone, represented, unrepresented, old, young, nothing specific. And then the waterfall goes down because some of those people that are denied, right, appeal for reconsideration. Not all of them. We know plenty. Shana, you probably had them where you got someone who said, well, I applied and then I got denied, so I gave up and now I'm trying again. So yeah. Those people are not included in that next waterfall down to recon. And I don't know what the percentage are that do appeal for recon. I don't know if they give us that. That would be interesting to know, though, I think. So what percentage of the people that were denied an initial that went to recon then win, which is a smaller amount? And then of those people that are denied on recon and go to ALJ, how many of those prevail? I will say the big takeaway was, and I got this from, I forget if it was Nosker or Nader, that it's basically the same as 2024. And I think the big point of that is they actually had far more cases because they started speeding things up a little bit and using some technologies to make things go faster and maybe better placement of employees and stuff like that. So they had a lot more cases, but the percentage of wins losses didn't change because people were like, they're gonna deny everybody. I'm like, where do you get that stuff? That clickbait stuff is not your friend. So what even the big organization was saying was it looks like it's about the same in terms of where they all fall. And so then, you know, I guess every year they put it out. I've only gotten my hands on it sometimes, so sometimes it's harder to find. And I used to get it from some place, I think it was out of New York, like Empire or something. But now Nosker shared it, so that was kind of cool. Are you familiar with that one, Shana? Yeah. I'll send it to you.
Yeah. Okay. I'm looking at it though. Yeah.
Yeah, it's good. I'll end up posting it probably someplace on the channel, maybe for the members or something, you know. But I'll definitely do a video on it. All right, so Shiloh wants to talk about the adult function report. People are always interested in that anyway, since everyone's got to go through it pretty much, barring very, very few. I've had a few cases where the person's, I think because they thought the person was going to meet maybe a compassionate list, you know, compassionate allowance. Have you had that, Shana, where they're like, I maybe had it like twice in 20 years, where the adjudicator's like, well, I'm thinking if we get this medical evidence, we don't need his function report, you know? And that would only be if they have a listing, right? I mean,
Yeah.
otherwise they have to because they have to do an RFC. All right, so Shiloh says, adult function report for PTSD claim, question number 20. Just to remind everybody, question number 20 is with all those, it's like little chart of tasks, you know, lifting, sitting, standing, walking, stair climbing, blah, 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 understanding, following directions, getting along. That's number 20. And he goes on to say lifting, squatting, bending, standing, reaching, walking, sitting, as I was just saying, and all those. And then I guess his second thing is concentration, understanding, following directions, like I just said, and getting along with others. Can you help with that question? You would have to tell me what in fact you need help on with that question. I could give you some generalities, Shiloh. First of all, is there anything that you would say to him?
Just need to be descriptive as to what of those things that you have problems with. Like, do you have problems sitting? If so, how long can you sit before you need to get up? If you can't lift more than a gallon of milk, tell that. If you can't stand for more than a few minutes, you just need to be, descriptive as to the problems that you have with those issues.
Yeah, I agree. And I would add that if you're thinking, well, I can do that, therefore, language of the question is something like, are these affected or limited or whatever? I see some people not check things off because they're like, I'm able to do that. And that's not really the question. The question isn't, are you able to do it at all? The question is it affected by your conditions? And by the way, old age degeneration is a condition, guys. So don't say, well, that's just because I'm 55, No, that counts. The beauty of it counts. This doesn't have to be from some disease or known injury or anything like that. Our degeneration as we get as old as I am is a real thing. I cannot do probably 60% of what I used to be able to do because I was a pretty strong person. And even like 2 years ago when I did this fitness challenge, I got really in shape. And then that's been 2 years. And now I'm kind of back to. So it's kind of like something you got to keep using it or losing it. So that's one thing I would say. And a way to look at it in your mind, and you guys have heard me say this probably a gazillion times, if you can't do any of those tasks for as long, comfortably, or as repetitious, without any kind of discomfort, as you could when you were 20, there's something there. And the question is, you don't even have to know exactly what it is that's wrong with it, necessarily. Just put it down. And if you have a decent representative, they're going to be looking at it. And they're going to inquire if they don't see an impairment that causes that. You've never said that your legs were weak, but you're saying, yeah, my legs get weak. Now they're going to know to say, hey, you need to follow that up with your provider. Maybe get a specialist, a neurologist, or someone's spinal, whatever, that's going to be maybe affecting those legs. But you want to put that down, because if you don't put that down and that function report ends up going to an ALJ, he's going to note that you said that was not a problem. So even if you testify at hearing that you have all these problems, because now you've talked to a representative and you know that that's something you should have said, it doesn't look good that before you said no and suddenly you say yes. It's almost like you're just changing your mind. So it's definitely more helpful to put it down early on with that understanding that if it's a weakness or something that is not as good as when you were 20, back when we were like immortal and super men and women, that's what I would put down. That's what I would do. That's a broad thing, though, Shiloh, because I can't really answer to your specific case because I don't represent you and I don't know your case. Shiloh does continue on to go to say, I have to lay down a lot due to panic attacks. I also stop mid-sentence sometimes when talking to someone if I feel one coming on. I have to stop talking to get myself together. It feels like I'm about to vomit. It's embarrassing. Yeah, I can imagine. Do you want to add anything to that?
Again, just have to explain anything that you do that would be deemed as not normal, what any regular so-called person can do, and just needs to be explained how you do it differently or aren't able to do it and why.
Very good. Yeah. And she makes a good point, how you do it differently. Like if you do something differently than what the human body and mind wasn't originally intended for us to do, that I would explain, because that's kind of a workaround. And
because a lot of people will put on those paperwork that they can do dishes and they can do laundry, and the judges in the Social Security office assume that you can, if you just put that you can do it right all at one time and don't have any problems with it. It needs to be explained that yeah, you can do a load of dishes, but it takes you 5 minutes at a time. It takes you all day because you have to do a few minutes at a time and sit down, take a break, and then do some more. Or you have to do laundry and get somebody else to get it out of the dryer or put it in, you know, out of the washer. Anything that you do differently than what a so-called normal person would do.
I totally agree with that. I know it's hard when it comes to the mental health aspects of it. Shiloh, I had just put out, you probably saw it, it was a number of weeks ago, how to deal with the function report if you have a mental health claim. Because some people think it's all physical and it's really not. And you pointed out a few questions yourself, Shiloh, that's in section 20 about memory, completing tasks. You've got it hands down for talking. I would be checking off talking, that your voice freezes up because it's part of, you don't even have to say what the diagnosis is. Just say suddenly, very frequently, I become unable to talk. You don't have to be the doctor and say, and that's because of this diagnosis. In fact, I wouldn't do that. Your claimed impairments are already elsewhere. There was something else I wanted to say about that. That would obviously affect your concentration and your probably ability to complete tasks, Shiloh, because if you're out trying to go to the bank or something and you get this panic coming on where you can't think straight and you can't talk and you feel like you're going to vomit, I don't know if you leave the room, like, do you actually go and escape the situation and, take yourself out of the situation, which means you don't complete that task you were going to do in the bank? That would be completing tasks. I mean, it can be, more specific than that even. Let's see. Laying down due to panic attacks. You could say, and that would be something, I don't know, if your panic attacks are daily and that makes you, like, you're going to have them in the middle of the day, do you have them at home when you're not even in the work environment? That's kind of important too, because that shows that would most likely then happen in work environment also. What else? And if so, it pulls you out of your day. You got to go lie down. Lying down is not a work-related posture. So that would be off task. So you're claiming something that would put you off task. And then, of course, the hardest part about it is getting that in your medical record as such. So you have to talk about all that with your mental health therapist. And if you're on medications or getting something prescribed by an MD or a DO or a nurse practitioner for mental health, anxiety, what have you, you want to make sure that talk therapy is pretty frequent, since you're saying it's a very serious condition affecting you every day, and give those details and say, I just really want, you can't really say, I want these details in my record because I'm filing for Social Security disability, unless she thinks that you should be filing for Social Security disability. If you expound on it enough, I think she'll at least, and probably you have anxiety in your sessions, is my guess. Hopefully she's a competent recorder. What do you find with that, Shana, about therapists recording things like that are told to them, and the issue that often happens, but not always, where they withhold those psychotherapy notes about those details? So those should really be in the mental status exam, but they're not. And then they say, well, I don't have to under HIPAA, that's the little carve out they have, that little nasty carve out they lobbied for, where they don't have to share their notes. And so then a claimant might not have any of that evidence available to him because his own therapist, who's supposed to be looking out for him, chooses not to share.
Yeah,
Thoughts?
I've only had that happen with one therapist, that she doesn't make any notes to be given out whatsoever. She only makes notes for herself, which is a problem. And unfortunately, when you're going through this process, you can't have that, because if nothing is provided to Social Security, it equates to them thinking you aren't getting treatment. It doesn't matter if you are, unless I don't know how. That lady I did talk to, she did send an email and say that she has provided forms for other people on that person's behalf, and then that if I want specific information, I'd have to pay for it. And I can't do that, because then it looks as if I'm paying for her opinion, which is not what it makes it a mess. So, but she did send me the forms or paperwork that she did fill out for the other people that, for whatever it was. So I appreciated that. But and I know the lady, and I would like to send her more people, suggest that they see her, but without the records, it's not going to help anybody when it comes to Social Security. But you just gotta complain, and if you say things enough, hopefully somebody puts it in the paperwork. When you go to the therapist and doctors, you just gotta act like you've never told them before, and make sure you're being very vocal about the problems that you got going on, and hope that they put it in there.
Yeah, it's almost like a numbers game. Say it enough, and sometimes it's going to get
exactly.
in. So it's almost like a numbers game. What does that lady you're talking about? Does she give? Is she willing to? Does she automatically? Does she give anything such as, I've been seeing him from this date to this date for weekly therapy for anxiety? Does she say that?
She said that she would do that for me.
Okay.
Because I think that
she's probably been violating HIPAA. by not giving, because that's the stuff that
I just don't see how they cannot give, like, there has to, you would think that part of their requirements are to make some kind of note that is available to, I understand some notes not being available to the client because of the things that they might say,
about other people, like,
or whatever. But at some point, there should be something that is required to be given to at least third parties like Social Security that shows that they have been treating. Because otherwise, the only way to prove it is to get billing treatment, and that still isn't going to show what you're going there for. It doesn't help, show
right
that what the treatment was for, unless there's DSM, diagnosis on there, and most billing doesn't have that.
Right. And then, of course, the diagnosis, that little bitty piece of information they give,
it still
goes nowhere towards severity. No. It doesn't.
No.
So now you have no medical evidence of how severe.
You need at least a little detail. Yeah.
How it limits you in day-to-day functioning, right? One can file a complaint with the Office of Civil Rights. It's very easy. It's online. They even let you fax it in, and they have this whole little form where you explain, and you can attach any proofs. Like, I asked for my record, she said no, and she's allowed to withhold the psychotherapy notes. I think a lot of them do that because they feel like they didn't do a very competent job and they might get delicensed. I think some of them just sleep and don't even take notes, so I think that's part of the problem too. But you can file it, and I think when they get a complaint, like if you say, I asked for records, she didn't give me the XYZ, I would look up the little blurb. It's readily available on HHS, government site and all that, about what part constitutes the stuff they can withhold and what part doesn't, and they must provide. And I think mental status exam at each session is something that they have to provide. And then saying she doesn't do that. And I've asked her over and over again. And if they get enough on the same person, they can sanction them. I do believe, not 100% sure, but I do believe every time someone sends a complaint, you can't do it anonymously, and you probably need to attach something, maybe, I don't know, but a complaint where they're not going to go and do anything big, bad, biting. They send the provider a letter saying there has been a complaint against you for not providing the records required under the law. We suggest you do that. And so at least they get a little wiggle in the ear from the people that could actually bite them hard, which they don't seem to do unless there's like a ton of people complaining. But I was going to say, if everyone sent in the complaint, when it's justified, when you can't say she didn't send her psychotherapy notes per se because she's not required to, even if you beg her and sign off on them. Unlike physical doctors that have to send all their stuff. But if she didn't send mental status exam, it doesn't say anything about anything. She just said start and end date. Go look at the list. And I just think everybody should send that up so that the Office of Civil Rights can do its job. Because right now I feel like it's a useless, toothless animal that really does anything, except in the very rare moment every couple of years it heavily sanctions some medical office for privacy violation or occasionally for not providing records at the proper cost and stuff. So I don't know. It is one of my pet peeves in this whole practice, Shana.
Yeah.
It says that I've had people that were stuck under a bridge living for a good long spell that he shouldn't have been, because of ignorant providers like that. Okay, Shiloh goes on, and then I'm going to look down and see if there's other questions, only because I don't want Shiloh to
I had
accidentally
one more.
usurp the whole thing. Yeah,
or that person had made in that one of their comments was stated she turns the TV on. Okay, so that is one of those.
Is that down below?
Yeah, it's down below.
Well, go ahead.
But she mentioned they mentioned turn the television on. Well, that's one of those things that also can catch you up into with Social Security, because if you say that, it makes it sound like all people will say that they watch TV. Well, it makes it sound like you're doing nothing all day but watching television. In reality, most people that with mental health issues especially only have it on in the background. They can't sit still. Their mind's racing. They can't pay attention to it. They can't concentrate on watching a 30-minute show and keeping up with the story that's going on. And they tend to watch the same shows over and over again because they've missed it so much, and eventually they've watched the entire thing. But that's going to be one of those things that I don't like my clients to put on their forms, because it can come back to bite you later, because they assume you can do it, like, sit there and just watch TV all day.
Yeah, and a lot of people do actually have the TV on all day. It's to keep the company, and they do look at it a little bit. But a lot of times also, and I think if this is true, you could say it if you qualify it and say, I'll have the TV on, but I can't remember a thing after 5 minutes. Or it's in
Exactly.
the background, so I'm not so lonely. You know, I have tinnitus, and I just need that to try to, you know, so I don't hear this so much. I mean, there's ways to skin the cat, but
Yeah.
you cannot leave it blanket like Shana says about I watch TV all day. Well, I wouldn't anyway. I know someone with purely physical problems, I might say, this is all I can do. I have to lie in a recliner for like, except for maybe 2 hours a day when I can get up because my swelling in my legs is so immense and my feet and the pain. But then
And
I would
also,
also address if you're not being able to focus on it all that much and you're watching the same shows, because I don't even
yeah,
remember what it was last week when I saw it.
because people, even with just physical pain, most of them are adjusting constantly to try to get comfortable. So they're still not concentrating and paying attention to that show.
Yeah.
So again, it's still that plays to the off task issue.
I'm just scrolling down. We'll come back up to Shiloh's other things. I just want to see if there's another question so I don't make someone wait while Shiloh gets an entire consult on function of not that you don't deserve it, Shiloh, just saying. Let's see. Oh, I see Rain Gal is in the house, brand new, catching my first live stream. Nice to meet you, Rain Gal. Adam Solt is in the house, one of our favorites. Hi, Adam. Furry Plant, another fave in the house. Furry's got a question, so let me jump down here, Shiloh. I promise we'll get back up. Furry says, would you recommend notes during a phone hearing for a grandma being asked about grandson's conditions? Thank you, Ms. Stephanie. For a phone hearing, it's because you probably don't want to forget any of the points you want to make. Is that right, Furry? I don't really think that's a problem. And honestly, I don't know the judge is going to, if he doesn't ask and he doesn't initially say, I want no note taking during this, you know, no notes available. I just want you to speak off the top of your mind, which I've never heard him say in a hearing, but I don't do phone hearings. I try to avoid them. I don't think it's a huge problem then. I mean, if he suddenly says out of the blue, by the way, if you have notes, get rid of them. Well, then you're going to have to do it because you kind of have to do what he says. Not that he can see you, but you know, you don't really want to be dishonest. But I don't think he's going to say that, and he's certainly not going to see them. What do you think, Shanna?
There's nothing wrong with having notes. I have notes that I use at every hearing to make sure that I hit all the key points and all the issues that are relevant. And so there's nothing wrong with, if you're not represented, to do the same, just to make sure that everything's talked about that you feel is important.
Yeah, I will say that we are held to a different standard, though. We have our notes. We've actually given them the brief, so they know what, you know. So we should, for sure can. I think the concern is that the judge will think you could be reading your lawyer's directions. Do you know what I mean? Like, and it's not really your answers.
Well,
But
I mean, that's
again,
no different
Grandma,
than us prepping them before the hearings. I mean,
right, and we have to, and that's absolutely, and that's not a problem either. He would expect that, but I just understand there could be times when they might frown on it. Might doesn't even mean they will, because I think sometimes a person could say even.
I mean, don't read something, make a list and then read it off. Like, just make sure that everything is talked about.
It's because it's got to seem like it's coming from your own personal knowledge.
Exactly.
Yeah. But of course, if you have pinpoints and you're going, oh, my knees, Judge, this is what happens with my knees, and then you're actually talking to him like this, you're clearly not reading. You just needed the reminder that you had to bring up about your knees when he says open-endedly, so tell me about your problems. You know, you don't want to miss anything like that, you know, because if they're going to deny, they always pick the things that you missed, even though you don't have 3 days to tell them everything. So I don't think that's a bad idea. And again, I don't think it's a big risk either. And I think for the reasons you say, Shanna, but you do want to also be as eyebally, eye to eye with the judge as you can while you're talking to him, separately from, you know, the fact that you have. Let's see. I think brown-eyed girl. Hi, brown-eyed. She was here last week. What benefit is it to a claimant's attorney to not contact client at all until hearing? Meaning his office never asked you for like data or medical updates or something like that? Is that what you're talking about? Because that would be inappropriate, I think. But if you're talking about just not reaching out to you to say, hey, hello, just wanted to see how your day is, we're probably not going to do that either. We're working. But, you know, I don't know. I have a really robust messaging communication system through a particular company that my clients and I use. So there is a ton of contact both ways through that. I know some people, we've been through this before, want a phone call. I'm like, nope, we don't deem that it's necessary right now because you just had a question for yes and no. We just gave you the answer. You don't need to reiterate it on the phone. And the problem with phone advice or discussion is that most of our clients have memory issues, or they're not going to understand it. They want to hear it again and again and again. And with the written answer, you can go back and read it again. And you can say, I don't understand this part. Can you just, So for time saving in an area of law where the margins are tight and we don't get paid by the hour, we have to do it in a way that is very efficient and covers you so you can go read the answer 10 times without having to call us 10 times. Anything to share about that, Shana? You might do things differently.
We don't reach out to them unless we're working on an appeal or something, we go through the medical records and something comes up and we have a question, but they are more than welcome to call at any time or message the Facebook business page or send an email and let us know like their updated treatment. I would rather somebody tell me every time they see a doctor than to never hear from them, because there's so much going on not just that one person's case, but on all of them, that we have to keep up with deadlines and things like that on a daily, that we don't have time to reach out and just say hello. But if there's a change in medical treatment, a new diagnosis, or a new doctor that you're treating with, call your representative's office and tell them. Make sure that they're aware of it. Don't wait for them, because not all offices and representatives are equal doing what they're supposed to be doing.
Yeah, I mean, we're kind of anal around here about, we actually have a dedicated message thread in our company portal, and each client has their own account in there, I guess. And it's a dedicated, and I'd say like 98% of people get it and they remember to put it there. And it's where every time you leave a doctor's appointment or MRI, like whatever it is that's going on, every visit, even PT that you do 3 times a week, you go in there and you say A, B, C, D, who, what, when, where, and it's a big long list. And then like if someone's going a lot, I always say the more you tell us that you're going, the more we actually get that information to the adjudicator in real time. So if we see like they went to ortho, neuro, and 3 rounds of PT all in 2 weeks, we're going to be communicating with the adjudicator about that every 2 weeks. We literally take the information, we put it into a letter, and we shoot it up to the ERE, the electronic file. So that adjudicator has no choice but to know that this is what happened. Other times it might be a conversation with the adjudicator, but usually for sure, always in writing, because everything with us has to be in writing. So I think it's really important. And if your rep doesn't have that same kind of system we have, leave a message on their voicemail, right, Shana?
Yes.
Then they're going to be able to document your file and do what they have to do behind the scenes with that information. There's a handful of people that just, have difficulty doing that. Their cases are weaker because of it. We send reminders when we haven't seen any treatment in 6 weeks. We'll message them in the portal and say, have you not seen anyone in 6 weeks? So it's a give and a take, but it's that's like their one big responsibility. Treat and tell us about it, right?
Yeah.
We're going to do all the legal.
We'll do everything else. You go to the doctor and complain, and let us know that you went to the doctor.
Yep, absolutely. So huge, guys, so huge. So brown-eyed girl, so it depends what you mean by no contacts. Like I said, if you're looking for coffee time and chat time, you're probably not going to get it. We're all busy. We're trying to win your case for you and 100 other people. If what you mean is they don't call you until they are on the phone for a hearing with you, even if they do, I mean, I'm sure Shana does the same thing. We do much time of hearing prep. I do mine closing time to the hearing, like same week, and preferably like 2 days beforehand, but sometimes it's 1 day, sometimes it's 4 days, depending on people's schedules. But we'll have anything from an hour and a half to 3 hour powwow, where I'm explaining what the steps are going to be. And then I'm going to go through all kind of questions that might come up. And then if there's issues like, we might want to, if the judge says anything about it, I want to talk to you in advance. What if he says, will you amend your onset date to your 50th birthday? And I'll be like, this is probably something we're going to want to strongly consider. So let's figure it out now, whether if he asks that, you are agreeable. And I was explaining, because he's basically saying, and I will ask him on the record, Judge, are you saying that you're fighting an award with an amended onset date? I'll say it right on the record. So I get it kind of in the hearing record and kind of carves him in. And not that he needs to be carved in, but just in case there's some weird glitch, because I've seen that before many years ago when I was still novice and able to be, what do they call it, punked. But yeah, those kind of issues, and they're not that common, but they do come up. And then that's where I go through all the functional questions that are similar to a function report, guys. So if you're pro se, I would say review that before your hearing, see what your answers were, see if you're in hindsight you made mistakes about any of them, and how you can rectify that at hearing, how there's a change or you weren't looking at it that way. But those are a lot of the questions that the judge is going to ask you. And that if he doesn't ask one that you think is important, then you want to give your answer to that. And you could ask yourself, because you're directing yourself. You don't have someone like Shana or I doing it. I don't know. That's kind of how I how we roll, you know. So it's anywhere, I'd say on average 1.5 to 3 hours going through all that. And that's where I'm taking my notes too, to know what your current answer is for something, so that I take the notes. I don't necessarily ask you all the questions that we talked about, but like, let's say you went on a vacation to Europe. I've had that happen. And the judge often, sometimes, first of all, you open your mouth to your doctors or your nurses or your medical assistants, and now it's coming out in the medical record.
The one note that they make, yeah.
Yeah, and the judge is going to definitely see that. And hopefully, if he does and it's a problem, he asks about it. And then we will have already covered that fact, because one of the things I ask you at our pre-hearing is, now I'm just going to ask about vacations. Have you gone on any vacations? I heard judge say out of state, and that's probably usually how it would be termed. And then I'll find out, you know, things that they didn't necessarily say, didn't tell me about during dependency, and then then I'll flesh it out. Like one time, Shana, it was the person did go, but they went with disability accommodations. Both spouses went, and they were. I didn't like the fact that they went. It was a birthday, 60th.
You never like it, but you got to deal with it.
But I didn't like it. But I'm like, but we have to address it to make it as non-bad as possible. And that was a young person in their 40s, so it was already one of those cases where you're like, it was, and it wasn't like 10 back surgeries and going for their 11th. It was more, Anywho, hope that explains there, Brown Eyed, all the different aspects of that question. JC says, if one gets on SSDI and then does no work for 10 years, would their DLI expire or would they still be protected? If it expires, would this pose a future problem? I know the answer to that. I don't know if you're familiar with it, Shana. If you are and you want to take it, go ahead.
I mean, it is going to expire, but as long as they continue to draw, it's not going to be an issue unless they get up for a review and then lose benefits. Then it can be an issue.
Well, I will say this. Well, it does. It gets tolled. TOLLED, not TOD. So, like, while you're disabled, you are excused from working. You're excused from earning those. So what you had, let's say you had 2 years left of your DLI when you went on SSD and you won it, and your DLI was 2 years out front and it was glorious. You're still going to have those 2 years because it's going to be told, but they will continue. As soon as you get found to be not disabled, unless you get that appealed and reversed, that time will start to be eaten up. So you don't get penalized for being expected to earn credits when you're disabled and they legally found you unable to earn, but you will as soon as they find you not disabled. And I would think that, if you're appealing it, it almost doesn't matter, because when you're appealing a CDR denial, the initial cessation, they ask you if you want to continue your benefits pending appeal. And you're going to be, most people are, they get the 10-day window and they try to grab it. It's impossible sometimes, but they try to keep their benefits coming because they got nothing else. If you end up losing in the end, you will probably be, because the expiration, the protection ended, and that time period of the 2 years for the CDR is now non-disabled time, and yes, that will be tolling. So that in a sense is very dangerous. You just do get that reprieve where you start with what you left off. So if you have 2 years left or 6 months left or whatever, and you can, I'll just throw this in there, guys, if you are working part-time under SGA and preferably under TWP while you're collecting, you are now extending out your DLI. If you're earning at least 1 or 2 credits, will keep it pushed out the same amount. 3 or more is going to push it out even further. So, I'm always so big ho on people working part-time and keeping their benefits because they're disabled from full-time work, but keeping their DLI and growing their benefit amount. Actually, they're going to incrementally be growing that. So it's going to be bigger than it would have otherwise been by the time they stop working. But that's one way to protect against that danger of losing at a CDR, entirely losing, and your DLI, if you don't go back to work, it's going to bite you in the butt. So I don't know. Does that make everything clear, guys? It's something to consider. The dangers, like Shana expressed, and then the ways to help it, and the little tolling that does occur. So know what your DLI is before you win. You'll find it in your ALJ letter anyway, if you went to a judge. So now I was found, my DLI is not till 2026. I was found disabled as of 2023. That's 3 years. Okay, that's some buffer if things turn sideways later with CDR. But you can prevent even that and go get the full 5 years by earning some money and giving yourself a little more, quality in some ways, if you're able. Mike Page is in the house. Love to see you, Mike. It's awesome. Hello, Attorney Joe. I just wanted to wish you a happy Resurrection Sunday coming up. Oh, you too. I still haven't colored my eggs, Mike. I don't know if I told you guys last week. I was going to get eggs and try to get my friend to color them with me. We had a date for Sunday to color. I bought everything. I was like, because I said we got to do it at your house because my house has too many pets. And so that was what we were gonna do. And then she had a really bad migraine. She gets them. She's had them since she was a kid. And I'm like, no worries. I'm like, there's a whole week till Easter. But I might just do them without her because I'm not sure. I mean, she works during the week, a regular job. You know, I'm not sure if we're gonna be able to get that scheduled in. So I might just do them. In which case, if I do, I'll probably do them in the next couple of days, maybe before the weekend. But anyway, happy Resurrection Day to you too there, Mike. Ricardo's in the house, was here last week. Hi, Ricardo. Good afternoon to you too, my friends. Mike Page says he wants to wish everyone a happy holiday. Ricardo says, I'm just curious, is it just me or is the sound not working? Shana, you can hear us, right?
Yeah.
No one's saying they can't hear. I think it might just be you because I would have been, I'm scrolling down, someone would have said something.
Yeah, I was going to say, somebody would have told us by now, I would think.
Yeah, because I ask in the beginning, I always make sure they can hear me because Shannon, when I first started doing this, it was a learning process, you know? And it was pretty funny, actually. Let's see. Jen Mee's in the house. Hi, Jen. Jen's got a hearing coming up. Not with me. She's got awesome representation elsewhere. Shanna says, hi, Stephanie and Shanna. Can hospitalizations, long-term treatment, psychotherapy notes, RFC evidence, enough evidence for excessive break absences to where the VE would have to acknowledge hypos as no jobs? Well, I have a way I want to word this a little differently. The question is, if the RFC says something, the VE gives you a pretty flat answer that anyone can look up in a book. So it's really what the hypo is that the judge does. Your job is to convince the judge of your RFC, not the VE. The VE goes with what he has to go with what the judge asks him. And the judge, you know what I mean? So your whole persuasion is to the judge, not to the VE. Shanna, what do you think? Is that, am I reading that right?
I think so, yeah. The VE will say that there aren't any jobs, but it's based on the judge's hypothetical, and the hospitalizations and things like that are going to contribute, depending on what the issue is and how often they are and things to that nature, are going to also add to not just the excessive absences and breaks, but also to other aspects of the RFC, just depending on what the issues for the hospitalizations and things are.
Yeah, and Jen Mee, remember your attorney is going to, or your non-attorney rep, I think you have an attorney though. She's going to put that, let's say the judge asks RFCs hypotheticals where the RFCs don't mention absenteeism or off task. Your attorney's going to. So she's going to give like a fifth hypothetical or a third or whatever, right? We always say, well, here,
always
anytime she adds a question that adds a limitation, that's considered a new hypothetical. Even if she doesn't call it hypothetical number 4 after the 3 from the judge. You don't have to be all formal like that. I put that in to nearly every case because it literally is so true for anyone with from physical or mental. And if you have proof of absences and proofs of breaks and that treatment you get, Jen, being if it's frequent enough, can not only just show that for those 6 weeks, like if someone is, they have pancreatitis and they're in a hospital for 6 weeks, and that happens every year, 6 weeks of work is potentially going to, and it's recurring, be a job killer. Any other kind of hospitalizations where, you have to be in. Because it is absenteeism. One could argue, well, FMLA would cover 12 weeks, but I don't know that that's something they're allowed to consider. They're not allowed to consider, they can get an accommodation. That's not considered a job in substantial numbers. So,
and depending on what the hospitalization is for, that the recurrence of those hospitalizations can also trigger a meeting of a listing as well. So it's just too many options.
Right. It shows the
yes,
severity,
it's going to help
as well as the absenteeism.
Yeah, but it is going to help in the overall RFC, yes.
And get it well documented. I mean, that being in a hospital is already documented, and that would be pointed out in the proof. Like if that were me doing a brief, one of my arguments is the schedule, the need for treatment, and the hours it encompasses or the days are so overwhelming. It's inconsistent with full-time, reliable work. That would probably be. If it's a case like that, that would probably be one of my pieces in there specifically. I mean, a lot of times the absenteeism people are talking about is more sporadic, which you might be also talking about, Jen. For the ones that are like, I was just home because I didn't feel good today, and I didn't function within my home very well. Those are harder to prove because they're subjectively stated and they're not in the record. So that's why I always say, periodically, feed your providers what your day-to-day, like in terms of task limitations because of symptoms. I mean, I'm to the point where providers are such poor recorders and listeners that I'm having, I'm often suggesting, in between, if your visits are 3 months apart, set up something in the middle, and whether it's through the portal messaging or, which by the way, will not generally, as I understand it still, come out if you download the portal records. It's a lacking on their part. I can't believe they don't include it. But
you
if
can get to it, but you have to go into the
screenshot, it's nasty,
Yeah,
right? Each one, one way or another, you're going to want to get, if that's an issue, that kind of proof in that record. So worst comes to worst, you portal message them, then you screenshot them if you have to. This is what a judge told me. If the judge's office does a HITMR, that's the automated ordering of the records, because the SSA has a prearranged contractual arrangement agreement with that big health network. It's usually big health networks. They, with your, always with your 827, they now have the authority to go in and do a HITMR, which is hot. I don't even know what it stands for. And they can download the full set, which should include all those messages. But when you do it through the portal, it doesn't work the same way. Yeah. And I think they need to legally change that, but that's just me. Or you could fax in a letter if you don't have a portal. It's a mom and pop, and I would believe by law, they probably have to put that in your medical file. And so by law, if they get a medical records order, they have to copy the whole thing and send it to you, or send it to the OHO or whoever orders it. So important, particularly for medical, those absences that are based on symptoms that no one knows but you and your family, So that's a way to kind of get it to show up in there a little more concretely. And it's showing up from a year ago by the time you get to your hearing. So it's not like you just testifying to it. Well, Judge, 3 days a week, I'm literally in bed with pervasive depression. It just wakes me out on a, or whatever the situation is. Ricardo, giving lots of loving. Ricardo says, you two are famous. Really? I wouldn't go that far. But you're sweet. Jenny says, I gave my therapist sentence notes up until my first ALJ hearing, and I'm actually not giving them for the remand hearing. Giving updated RFC. Technically, are you aware of this rule, Shana? Came about a few years back, maybe like less than 10, I'm thinking. You are obligated to send any records, good, bad, or ugly, in your possession. Sometimes I tell people, don't go get them if you think they're going to be bad. Like just, if the SSA wants to get them, that by all means. You can't hold back legally. And I'm not familiar with any cases where the SSA went after anybody because somehow they determined that you had them and didn't give them up. I mean, how do they prove that? And do they have the resources to even try to do that? I just wanted to tell you what the legal requirement is. So it used to be, because it's a non-adversarial process, that wasn't like a stated rule. Maybe it was an expectation. Now it's a stated. And that's true of us too, as representatives. And I tell my people, I'm like, listen, if it looks bad, I still got to send it in, and I will send it in.
Even though we want to cry when we do it, we have to send it.
Right. And so then the goal is, yeah.
Because hers is like, wasn't it mental health? So that would benefit her regardless, unless they're not saying anything, which is not her fault. But not sending them makes it look like she's not getting that treatment either. So it definitely needs to be sent anyways.
I just got a load of dogs that just entered my office because the babysat dog my daughter is letting out, and she's had a few squabbles with one of our old crabby dogs. So for the little dogs, the mid-sized dog safety, the visitor, I'm like, they're coming in here. I would show them to you guys, but it's a pain. And plus Tasha's here. Yeah. Sometimes when we have to send in stuff that we don't like, and I wonder if Jen might be talking about, I see this a lot. The therapist notes say they all within normal limits. So she's doing okay today. And they don't say anything else that makes a clearer picture. And that is damaging. That is very damaging. And this is why I say therapists, a lot of them are incompetent. They hate me. But if that's the case, I wonder if I found out from one guy who explained to me why they do that. He worked for an entity that I guess gets probably Medicaid. And he said, we have to say that. He goes, I know for a fact that this guy, shut your mouth, that this guy would probably be dead without this therapy. He is holding his own. He cannot go to work. He gets through basic life because he has this backup. This is as far as we can get him. So in order to keep treating him and getting paid by Medicaid, this is my understanding, we have to say that he's doing well, because otherwise we're not
doing their job.
The perception is that we're not doing it. He doesn't need it anymore, and you're not, Because if they said he wasn't doing well, it's like, well, then you're not serving his needs. But sometimes getting him off of, say, dying of suicide is doing wonders in keeping him copacetic, but you can't throw him into a full-time job. That would completely destroy his psyche. So it is a tough one. And this guy explained it to me and how he almost got fired because I did ask and he did give me a synopsis. And it was really generous of him. And then I said, just send it to me. Don't even put it in his record through the bosses because the SSA is not going to share it to them. You know, like this is very confidential when it comes to me, to the SSA. That's the only people that are going to see it. You don't have to share it to anybody else. But he had, I guess maybe I didn't say that to him beforehand or whatever. But he had it in the regular file and then maybe his supervisor, I don't know what it was, but he almost got his butt fired. So he wasn't going to do it again for us. We did end up winning the case, but it took another round, I will say. It took another round. It's troublesome. It's a problem. So you almost want to, if there's a way to find out therapists who actually do their job and are not kowtowing to the almighty dollar, are not dependent on a Medicaid, entity that they work for who says that this is the case, or maybe if they just learned how to write their records more accurately and say, he's at baseline, and because of therapy, he is, and his sheltered environment that he lives in, which is no work demands, he is not experiencing suicidal this or that, or it could be panic attack, whatever, the person's diagnosis. It's this structured and sheltered environment, including our wonderful therapy, that is preventing that. I mean, it's got to be creative and it's accurate. It's truth, I don't know. Good question though, Jen. Very good question. Jen says, I'm glad records aren't required. Well, oh, you mean psychotherapy notes? Oh, I see what you're saying. Yeah, but once you get them in your hand, if you have them in your hand, that's the problem I was talking about before about having to submit them. They weren't enough the first time, and the second ALJ just used and abused the details in the first set in a very mentally harmful way. Yeah. Could be Dreams says, I'm in the recon phase. I got a letter just like that about I have some limitations, but not enough to approve. Gotcha. Did you get a letter on recon? So is that a recon denial, Coop? So me and my attorney filed reconsideration. We've updated my medical records and treatment. Probably is really ending in. Yeah, that's all you can do. If your attorney can get the DDE from the initial denial, it might tell you a little bit about what they found, where they found that you were at, that your medical record said you were at, when you know that you're worse off than that. Do you do that now, Shana, now that they give that to us?
Yes. Look at everything, because what you can't find in one spot, you can find there in little pieces to get to the puzzle. It's coming handy.
Yeah. I mean, we can kind of sometimes figure out if it's a physical case. They obviously put them at this RFC. It's just going to do an automatic. But, sometimes they have it. It might not be. It might be a good RFC, but then they found they could do it prior work. So it wasn't the RFC. Ricardo says, is working online considered a good factor or a bad factor in any case? Well, that would depend. You want to go with that?
Depends on how many hours and what you're doing and what your medical issues are.
Working some, so many things.
Yeah. Working some is not about, people have to live and pay their bills, so they understand that, but you have to be under the SGA. And that if you're doing like call center work, but then you're supposedly got mental health issues and can't be around people, that's not going to fly. It just depends on the situation.
It's so, yeah, I agree. It's so fact specific. Mm-hmm. It's like getting through the weeds. You really got to do that. I will say that when the questions never ask about, do you work from home, like a computer person or something, or do you go to an office? And I don't offer it up because it's not asked. Because if they're working from home, I don't want that to be considered now. That's how their job was actually performed. So that all those things about being in an office that would prevent them from working now no longer apply. So I'm like, hey, unless the SSA asks me for that, I'm not giving it up. And it doesn't ask it on the work history report. So let's see. Jonathan's in the house. I had my perk SSI denied and SSDI, yes. Okay. So you had too much money for SSI, but SSDI, you could be a wealthy man, Jonathan. Right, Janet?
Then nothing.
That's the proper take, would you say? Like, all right, so the finances, Jonathan.
Better to not qualify for SSI if possible. You can get a little bit more than that.
Yeah, I think you're doing better in the end. And particularly, again, if you're going to go back to work part-time, it's much easier to do on SSDI than SSI. Half fights in the house. I have fight. Ricardo says, if turned down a closed period 10 years ago due to age and decided to reapply when I got older, good or bad for favorable decision? Any thoughts on that, Shannon? And then I'll just plug in after.
I'm not real sure about that one.
I'll just go off tangent here. You're older, you have a different RFC potentially. I mean, I'm sorry, vocational profile. You may have changed in a new age category. 2, you probably have new impairments physically.
Definitely.
So if you were mental before, maybe now it's mental and physical. And I don't know. What do you think about this? Someone who, now, if you went back to work in between, that means they were totally right on the other one. And, but let's say you still are not working and you're still treating and you're still trying to plug through life and then you reapply. Sometimes I think a judge, not so much an adjudicator, looks at the fact that this isn't someone who then did jump back to work, and particularly if they were a worker beforehand. But even if they weren't, like let's say there's signs that they were very troubled as a youngster, even if there was no SSI available or anything. Sometimes I think the recurring applications are positive. I mean, it's bad they lost before. It's unfortunate they lost before, but sometimes I feel like their existence on the next claim or claims can be an optic. It's not like obviously a legal rule. Any thoughts on that, Shanna? Did you ever?
I mean, being denied several times, it could be just not getting the proper treatment that they needed and having, things documented like that. Actually just got a man approved earlier, last Friday, I guess it was, that had a similar situation. He was working in like 2010, 2014, something like that, and applied through appeals council and never could get approved. And his date last insured ended in like 2018 or 19, but he didn't have the medical treatment to support an approval before. And he didn't like doctors, one of those type of people. And don't get me wrong, I get that. But when it comes to this situation, you have to have that in order to support with the problems you got. And I was able to get him to get a little bit more. Still wasn't what I would have liked for him to get, but thankfully he changed age groups and they graded him out at 55, but barely.
Yeah.
But yeah, otherwise.
So for the age, it wouldn't have been enough. Yeah, that's awesome. It's a good share.
But it all comes down to the medical records. You just gotta make sure you're getting treatment for any problem.
Treatment.
Yeah.
The mantra. Okay, Brown-eyed girl says no communication before CE or communication before reconsideration. How do I know they're building my case? How do you know your surgeon is actually doing? I mean, they don't get paid. Put it this way, is the way I look at it. They're not getting paid unless they win. To win the case, they have to do some work. Have you asked them to say, now for CEs, just to go off on that, I don't call my people. I have videos on it. So I actually have we send them a message through the portal that we have and says, all right, you got a CE, because they usually tell us when they get the letter. Because sometimes we don't even get it because mail's terrible. And here's information on mental, here's information on physical. That will tell you what we would have told you on the phone. And that's kind of my point. Like, you don't need to hear me breathe on you to get the information from me. So that's what we do with regard to CEs. And then I do like it when they tell me what happened. They can try to remember, particularly, mental, but physical also. Sometimes they'll just tell me because something terrible happened that they're really offended about. But other times, some of my questions are, did they, I'll either do it shortly thereafter or we'll go, like, if I get the CE report and I see that I know the person has bad arthritis in the fingers, and this Nimrod CE examiner said, able to button buttons, zip zippers, and tie shoes. And I'll almost always ask, did he test you for that? Did he have you do it in front of him? Did he ask you if you could do it? No. He just fabricated. And then that's something, I don't really rock the cart while we're waiting for an initial or recon decision, because I'm not going to rock a cart in case we might, I still think we should win now. But as soon as we don't, boom, I send that right up to the DDS and I say, this is a problem. And I try to send it to a manager. This is a problem with this CE. I mean, my client says this, and sometimes I'll get a 795 for what the client said. In fact, I pretty much always do. What do you think about that?
Yeah, I don't
Shana?
call.
Like, how do they know you are building their case?
Well, they should be hearing from you every now and then. Like I don't call everybody for CEs, but the ones I know that might not be getting their mail or whatever, like I do like to check in and make sure that they're going to go to them. But then of course some will call and tell us that they've got the appointment or whatever, and if there's anything they should do specific or take anything with them or whatever. But I always call at when it's time to do an appeal, unfortunately, after they get a denial, we do that and check in with them. But I want to, I'm in the process of setting it up to where, because I don't have like the program like you do that does the automatic emails and things like that. So they are kind of like on rotation.
They're not automatic, but it's just so
but
easy.
you trigger it or whatever. But it's a I've got them kind of like on rotation to be checked in with. If we don't hear from some people, with, so many weeks or whatever, we check in, make sure they're at least treating, and maybe we just haven't heard from them. Because my hope is most of them will contact me anytime anything new happens or they see a new doctor or something like that. And that a lot of them do, but not everybody. So I do have them to be checked in on. So you should be hearing from them at least once or twice in between, one way or another, whether it's text or email or phone calls. And that's the only way to know if they are working on it, is if somebody, but you can also call them too and see what they tell you and let them know about your changes.
Yeah, I mean, it's so funny because of the platform we use for that case management / whatever. The biggest thing for me is the communications, uploading, downloading documents, blah, blah. But I have clients, and probably one or two of them are here. I hear them. We're messaging like 5 times a week. It's hysterical. You get people that like don't do that, and then you get people that are like, "Hey, here's something," So it's funny because it's like you get to really kind of know people. It's more through, and I always say you're not going to get a phone call unless I believe you need a phone call for the betterment of your case, because we don't have time for that, because we really want to work on your case. Do you understand? Like not on your feelings so much, but the communication is easy, and when it's that way, it's like right in front of you. I don't know. It's something to consider. I know it costs money though, but it saves a lot of time. And I don't know, for me, I think my communication with my clients would be 80% less. I mean, that's how major it is in terms of being for efficiency. I don't know. And maybe I've been using it for 15 years. So bear with me on that. I know what I'm like. I have the way I use it. And it's got things in there I don't use. Like it's for all kind of law firms. So it's got like billable this. And I'm like, we don't do that. Thank God. That's not an added administrative task. You guys probably mostly know, like out there, we don't get paid. We get paid a contingent fee at the end if we win. And it's very discounted. And it's it's low margins. Everything is, I would call like low margin. So that's the whole point about being very diligent with every case, because you want to win every case. So that's the way Shana rolls. That's the way I roll. And so it takes very much hands-on of everything. And it's a ton of stuff behind the scenes, just checking, making sure it's like you're just constantly on defense and offense at the same time, right?
But I will say that not all offices are the same, like me and you, like if an office does other aspects of the law, they are not going to be as hands-on usually. That's what actually got me into doing this, is the fact that in my area, almost every office says that they do them, but it's rare for one to actually do them properly. So that is the kind of thing that you're going to get from them. You're not going to hear from them because they treat it as extra money. If you get approved, great. They got paid to do nothing. And if not, oh, well, they didn't lose anything because they didn't do anything in the first place. And it shouldn't be that way. So, I mean, check the Google reviews, talk to people. But if their hands in all the cookie jars, you're not going to get the same amount like you get from me and Stephanie. That's just the way it is, unfortunately.
Yeah, I used to always call it for firms that do various areas, and some of the real big ones do it, and sometimes the smaller ones do it too, because they're just trying to have more market share and more business, and they don't have like, I mean, I guess it takes a special kind of practice to be able to exclusively do SSD. You have to have built it, and and I always say the people that tag on the SSD, I say that's the redheaded stepchild of the firm. They usually don't know much about SSD law either. They don't follow it because they're so busy trying to keep up with divorce and PI and workers' comp and, you know what I mean? So Jonathan's another one who does just SSD. That's all he does. So, I think it's a huge difference. It's a huge difference. And I've said this before, and I said it recently in a video. I feel like the smaller solos who dive into SSD, it's like I don't want to use it's the passion, because it's like a little overblown, but they put everything into it because they're not dilly-dallying. trying to be jack of all trades, master of none. And I think they're going to be the ones that are more apt to do the hands-on, helping with the function report, reviewing it, making sure those answers are not screwy. You know, they may not type them up like we do, because I know there's different thoughts on that. And I know some of them will say, like, I don't know the resources. I just learned how to get that done, like in a very streamlined way. I definitely feel like it's like being I don't know, big Cadillac or a big Suburban. You take more gas. You have less, like, they can't put that much little detail in because they need to focus on the big money making cases, because they got all the staff, far more staff than we have. And and maybe they support these fancy offices for all their staff, whereas all of my staff has always been remote working. Always. Sometimes it's been, you know, by design, disabled people who can't go out and work full time. So this works perfectly. It's like within their limit, you know, and it's all contractor, you know, but it just, I don't know. I just think there is a big difference. If you're relying on SSD as your mantra, that's the thing you're going to be the master of, and that's going to be all your clients, you're going to know your stuff. You have to, because you need to win all those cases. In theory, you want to win all of them, you know, so you want to come, even if that's impossible, we all want to be as close as possible to that big number.
Yeah, because someone had mentioned to me years ago that I should get into doing like the black lung cases and stuff, and I checked into it. I can do them, but I don't have the time to learn about the processes and things that are required for those cases to do them to the best of my ability. So I won't do that.
And it would take away so much of your time on your heavy schedule now, right?
Yeah, I like learning the rules and regulations and keeping up with that kind of stuff with Social Security. I don't want to split my time with that kind of thing.
That's right. That's how I kind of feel like it is generally when it's not even just an SSD. I used to, when I first hung my shingle, I didn't even know about SSD. This is like, I don't want to say how old I am, but it's like 30 years ago. And I was doing New Jersey state law, and I was taking everything I'd done at the law firms, and then I was doing also stuff that any solo would do. Traffic cases, DUIs. I did low-level criminal. I did divorces, you know, and that is a lot you're constantly like, do you even know all the newest rules? You know, do you know, it was, I don't feel like you're the master of your game in any of it if you do that.
No.
Yeah. I don't think it works that well. And I also find that the way they ignore clients is a lot more, SSD clients, you know, they're not going to ignore the divorced person who's on the billable hour.
No.
Right. You know, they're not going to, that's the thing. That kind of stuff is bringing in money the second they open their mouth with you or take your call or read your email. Not true with us. So we need to get the endpoint. We need to get our clients to prevail, or else, you know, those many dozens of hours, you know, are pro bono with no beautiful outcome for the person we're trying to serve. All righty. Koki says, I testify for my grandson tomorrow and I'm a nervous wreck. Oh, you're going to do great. And there was someone else, Koki, that spoke to that earlier. I don't know if you were here. Gregory Penny's back in the house. Hi, Gregory. Hi, I was found disabled due to my low IQ back in 2020. I remember this from last week. My psychologist stated my IQ was extremely low range across all areas. I got my short form CDR back in June 23, and I assume I'll get another one this June. I don't know what your CDR, what your diary date is. My question is, if they ever wanted to reevaluate my IQ under a full review, will they send me to, that might be something you should actually have in your back pocket. I don't know that they're going to send him for IQ. They might send him, have you seen that? I'm thinking maybe have. I don't really think our IQ changes it. Isn't that like some innate thing? But we can gain skills.
Supposed to vary.
Yeah. I don't really have a firm answer for you, Gregory. I'm sorry. Anna, you don't either?
I would just make sure you're still doing your treatment, because that's what's going to come down to. It's not going to be, that wasn't the only factor that was taken into consideration when you were approved. So it's not going to be the only thing they look at when they reevaluate. So make sure you're still doing the treatment. That's what's going to.
Yeah. Now, what if you're not treating because it's just like hey, this is my IQ. Maybe you want to go get yourself reevaluated.
Yeah, it should have been more. I wouldn't think if it was just like a major, if IQ was the only thing, I wouldn't think they would do a review, because that's something that doesn't really change. It's going to be based on like other things also.
If it was, yeah, that's why she's probably saying it wasn't just the IQ. It could have been like you had bad anxiety, Gregory, maybe, or couldn't keep to a schedule, like that. The whole like
ADHD,
it's kind of like a different something where
like that.
you know, or there could have been other psychological factors.
Yeah.
I don't know if there was physical ones. If you can get a copy of whatever the basis was, that would be the DDE back when you were found disabled in 20, which, or if you went to a judge, Gregory, I'm not sure if you did or not, his decision will probably tell you too, I would think. And then you're going to know what things you got to be, keeping strong. KU Thunder's in the house. Hi, Stephanie and guest. That's Shana Justice of Justice Disability. How much weight do letters or statements from friends and former workers carry? I know they are good to have, but suspect every applicant file has them. What do you think, Shana?
They're not real important, but some judges do bring them in their denial letters more than anything. But you just gotta, sometimes they are helpful, but it just depends on the situation.
Yeah, I agree. Friends and family have every denial is going to say, and even an award, because the judge has to acknowledge everything that's said of magnitude, and that would be an entire statement from one person, as opposed to a little sentence in a 1,000-page medical record, which they don't have to give you every word that was said. The friend and family member has biases. Clearly, that's going to be expected, that they want you to win. So their word is not really something that's really objective. Whereas former workers, I think a little bit more objective. I wouldn't share that we're besties now and we're besties before we work together. If a former coworker, particularly a supervisor, if he's still in the job and he's got letterhead and he can do it, that'd be great. That's not often the case, though. They're hesitant to do it on letterhead. Although I've had owners of companies do it, which is nice. I definitely prefer coworker statements. And the way I've done it, and it's not that often because people don't often have relationships with their former coworkers after they've left. It's been a few years, but sometimes they do. It's just not that common where I'm at. But if a former coworker will say, yeah, particularly if they still work there, for some reason that just seems stronger to me as opposed to not. But I worked with her, when she's here, and here's what I saw. But I always want to talk to them first. So I always say, well, she talked to me, and then I can even draft up her statements that she tells me and send her a 795 form that she can execute. And that way we're only putting in what I think is going to be pertinent for a judge's consideration. And I think that will hold more water than a friend or family member. Generally speaking, I mean, there's always exceptions. Like if they saw you going into the break room a lot to lie down. I had one guy, they always saw him going to the break room to take off his boot because his foot would be like this. It was a car dealership, and then he had to do a lot of walking. We did win the case, and that person was really helpful. It was funny. It was like a young kid who was training to be a car salesperson, and here was this veteran car salesperson who was really good at his job. But the physical nature of that job, in terms of, it's not heavy, it's probably light, but you're on your feet all the time. Let's see. Gregory says psychologist. Yeah, I think you could probably do well, whoever's credentialed for IQ testing, probably a psychologist. Don't you think, Shannon?
Yeah.
All right. I'm going to pop into a Shiloh question. This isn't your function report stuff, Shiloh, which is still up top, but we still got questions to go. It's a different one. My therapist sent the info to SSA. They requested. All right. That would be her records or whatever. It was sent after I received a form from SSA asking for a CE exam. I assume it's a mental health CE exam. I thought they were going to review the medical before they asked for the consult exam. Well, they didn't have it, so they didn't know if you were going to get it to them. But I will say this, and do you find this true too in your area of the woods, Shanna? Even with this therapist exam record, sometimes they just want to confirm. It might be they find that to be, well, we got to see if we can believe what she says. If what she says describes you as disabled, let's let our guy look at him. Or they find that her stuff doesn't clinch it, and maybe their guy can clinch it in your favor. And then oftentimes it's a denial or not a denial, but it can go either way. It's really not.
Yeah, anything. I've got one that he has seen 2 ophthalmologists that agree with each other that he's got glaucoma. That normally that's something that gradually comes over years of time. This person has become practically blind in a matter of months. So I questioned it myself, and then the lady at the Social Security office did too. So they did end up sending, even though he's already seen 2 ophthalmologists about, the surgery and stuff and whatnot, whether it'll help or not. They did send him for a CE for that, as I think he just went to that the other day, so I'm waiting to see what the report says.
Yeah.
But sometimes I just need a little bit more to confirm, or just to make sure that,
Yeah. The statement I always understood, well, I don't know where I got it from, but I've had it in my head for like 20 years, is that they do a CE exam when the evidence could show you're disabled. It's just not quite clinched and clear, but it's possible you could be disabled. So in that vein, it sounds like they're trying to help, a plaintiff potentially with, because they might be, but right now they don't have enough evidence to know that, hey, She's busy cleaning herself. Ricardo says, business done the right way. We agree. Right, Shana?
Yep, exactly.
Brown Eyed Girl says, not at all looking for chat time. Yeah, so why don't you just text them what you need to talk about? I mean, do they have like I don't know, do they have a portal, or do they give you an email, or is there some other confidential way to ask questions? And are you saying they ignore you if you message them or leave them a phone message? I mean, if I get a message and it can be answered in message, that's what we do. I'll be dictating, or someone else, if it's like a quick, hey, did you receive blah, blah, blah yet? They don't need a phone call from me for that. And I don't even have to be the one to answer it. It can be someone else that says, I'll check the file and I'll let you know if we have it, or something like that. You know, sometimes, I mean, I have all these videos. Sometimes it's like, that's explained in this video. Cha-ching. You know what I mean?
Yeah, I'm working towards that.
Yes, you should definitely. It really, I mean, some of you know that I started doing this when I was just making video explanations of things for my clients, kind of internally, because it was the same questions getting answered over and over again. And if I spend all my time teaching on the phone, I can't be working on the cases. It's just a fact. So, and then I would just have to give up my day job and go be a teacher or something. Then it turned out that I can upload the videos to the portal, but a lot of times people can't download them to watch them because they don't have that much memory on their device. It could be a 40-minute explanation. So that's when I got the idea to put them up in the ether world up there. There was Rumble at first, and then it was YouTube. And YouTube, because it was simpler, there was more features available to help it. And then it was like, well, why don't you just let everybody see those? There's nothing proprietary about that. That's all just explanatory. So, and that's what I did, and that's when it ended up being kind of what it is today. That was like maybe 5 years ago, or almost 5 years ago. I always say Jonathan is the grandpapa of YouTube SSD. It's the grandpapa. But yeah, I mean, what happens, Brown Eyed, if you ask a question? Do they literally just ignore you? Because I think that's very wrong. I'm getting allergies this season big time. I don't know why. I mean, it's getting to be spring, but I thought that really cold winter would have made it a little less bad. Rain Gal says, scheduled for 2 CEs, 1 GP, so general practitioner, 1 chiropractor. CE with a chiropractor, huh? Any idea why the chiropractor? I don't know. That's very interesting. I mean, isn't that weird? Diagnosis, degenerative disc.
They always crack me up with that because they do use them for CE appointments, even though they don't see them as valid doctors.
It doesn't make
I don't
sense.
get it. I mean, it's only something for one of us to argue about if it wasn't to their favor. You know, like, well, you don't recognize them as the.
I wonder if they pay them less and they're like, listen, we think we're going to grant this person, but we just to cover our tracks, we have to have a CE. So let's just give it to
that person's 54, so that's definitely
So weird. I think it's weird.
I thought they weren't using them as often anymore, but I guess they still do sometimes.
I don't really.
I've not seen one in a long time.
You have not?
Not seen them use a chiropractor, no. Not in a long time.
No, I don't even know if I ever have. That might just be something weird out of your office, Rangal.
I know they used to use them a lot, but they said
you saw it earlier?
Yeah, years ago I've seen them do it, but I haven't seen it in a long time.
3 hip dislocations. Yeah. I don't know why the chiropractor. That is weird. I mean, is he just going to take x-rays and then, but
it's
he's not even
just
qualified to read them.
It's probably the range of motion testing.
Yeah.
But at 54, I'm not too worried.
And it's weird because they're both for physical stuff. Like, that's really weird too.
But with that age, I wouldn't be too worried.
Well, if I saw 55, I'd say that even more. 54 is tricky. We're talking about that. Yeah. And how for a number of years now, it seems like they're always trying to put the 50 to 54-year-olds into a light bracket so they can deny them. And then hopefully they have DLI left where they can then just apply again and then they're going to be 55 and they're going to prevail. I don't know. Very frustrating. Ricardo says, all this helps with becoming more aware of the way of having comfort and security of trusting the process. Yeah, I mean, there's a process, and when everyone follows it on both sides, like client and reps, I think it can be very, very positive. And I always say, like, we have a methodology. You probably do too, Shana. It's like we do don't. And you're expected to do don't. And that was something that developed for like 20 something years now. When I started, I was like clueless. There was no education out there. There was no YouTube. There was nothing. There was no law school stuff for it. Now you can find CLEs on it. I've given a CLE. So there's more to learn from. I had to learn it all from scratch, but maybe it helped me not learn anybody else's bad habits because everybody else was lawyers doing other things that were moving over. I hadn't been doing lawyering for other things for like more than, 10 years. So maybe I wasn't so burnt in that way. And and the last 5 had been on my own anyway. So I wasn't really ingrained to the old traditional ways of doing things because I didn't think they were very effective. Now that we had internet, I'm like, there's so many better things we can get done faster for people. But I do get pretty nitpicky. I mean, with our methodology, I call it. Like people can't just say, but I'd rather give you my information in this format. I'm like, no, here's a form. It's so that we see it the same way and my people see it the same way. So they're not going through a needle in a haystack because you want to send me 1,000 papers and not fill anything out. That's not happening. That would be a different lawyer you got to go to. Probably the ones that don't read it anyway. I mean,
Exactly.
they're not going to care how you send it. Virginia Gomez is in the house. Haven't seen you in a while, Virginia. Have I? A few weeks? Good morning, Chica. May God bless you. I hope so. Thank you. Your medical sources have 30 days to respond to our requests. I didn't get it in the first case, but second case is asking why. Why not ask me in the first case? Are you saying that you didn't know that rule? They didn't share that rule, the 30-day? That's a HIPAA rule, actually. That's not really an SSA rule. What they typically do, I found, and they had told me that this is what their process was, SSA. Send a request. If they don't get back in 20 days, send a second request. I think that's the way they make sure, they cover their butt by saying, what if they didn't get the first one? And then the person's already, now it's 30 days in or whatever by the time. And then they just write off the provider is not going to provide. And ideally, they would send a letter telling you that. So why not ask me in the first case? What are they asking you? Are they asking you to follow up with your providers? That's probably what that letter has. I've seen those letters. And those are good, particularly for pro se people. It's good for the representatives too, because we can't be checking every electronic file of every client every day to go through a needle in a haystack to see if you got something new. Rather, it would be nice if we get the notice that something's up in that file, right? On their side of it. I was always saying, Shana, like with technology now, you know how they text us a one-time passcode to get into the ERE every time we want to go in. And so they know how to text us. Why do they not have an automated texting system that says something new in the file on last 4 of social 1234? So the person's identity is texted.
Like that.
Oh my gosh, it would be so great. And it's got to be something actually changing in the ERE we can see, not any of that, the part they don't show us.
Yeah.
But even that would be better than nothing. Yeah, because then it could alert me. I don't have to sit there and hope that the mail gets to me, or one of our periodic automatic check-ins to ERE, which are not every day, because we can't do that every day. Or else, again, we would not be working on big things for our clients, like doing those function reports with them or whatever. The technology's there. It would save them so much mail, because if it could be where the attorney, like they text the attorney or the rep, right, the representative, about the fact that there's something in the file, and then they give it 5 days. And if their system sees that the representative went into that file, they don't have to mail that letter out. I in my last week's live stream, Shana, I think it was in the live stream, I was describing how I got, and I showed the envelope. I got this big, huge manila envelope. Inside it was one sheet of paper and a return big envelope. And it was a very routine letter that I don't even have to do anything about. It's like maybe a barcode page, which I don't even need a barcode because I upload things to the ERA. And I thought, and I looked at so all this paper, right, for a big envelope for one, the cost of mailing that was $1.90.
That's what I was going to say. If Social Security stops mailing out paper, I'd hate to see what a stamp would be for the rest of us, because that's about the only thing that's going through anymore.
Will be like way up here.
Yeah.
It is insane. And if they just had a system where, all right, we text you. Now, granted, text can fail. And that's why I say if they don't see that you went into the file within 5 days, then mail the attorney the letter. And maybe mail the client regardless, probably is best. Unless they do the same thing for them. They text them stuff. I just think the technology is there. It already exists. They're already using it for the one thing. Expand that, Whether you want to call that AI or not. AI has been in the SSA for years. I call it automation. But anyway, yeah, for sure. Like, oh my God, they would be, that was $2, $1.90 just for the stamp. That doesn't even include the cost of the labor that stuffed the envelope, took it out of the printer, the printing ink. It doesn't, the mailroom could be 1/10 the size. You know what I mean? Yeah. It's like, come on, just let me in there and let me fix your rules for you.
I get a stack of those
They've done one
other day.
It's like insane. And I was saying before, I don't know if it's still true now, because now I don't pay attention. But many years ago, like 15 years ago, or maybe even 20, New Jersey, which was my heavy back then. Now I'm a little bit more modern. I feel like I'm heaviest in California, believe it or not. Like California and I don't know why. Californians and I just get along so good. Every case I had at the DDS in New Jersey, I would get in duplicate 2 different envelopes with the exact same thing in it for every single client. It was annoying. And I sent a message to the DDS or the SSA or whatever method I used that was available back then, and said, you keep sending double stuff. I'm like, it's so wasteful. What are you doing? Can you get this up the pipe so it stops? Never, of course, got a response, and it never stopped. I assume it's still going on. Again, I don't read the duplicates now. So isn't that crazy? It's like crazy.
They do. They waste a lot of paper.
Yeah, and all the other expense that goes into it, labor, and
Yeah.
stamps. Umo's in the house. Hi, Umo. Hello, all. Has anyone ever experienced where a doctor has lied on the CE information submitted to SSA? I think you mean the report. Like he said something that's false. Kind of like what we were talking about before, maybe. I have seen it before.
Yeah, I have too.
Yeah. So when I talk to my clients about that, I go, now look at this report and you tell me if there's something factually wrong. Not his conclusion. That's not your business. That's not what we have clout with. Did the facts that he specified was anything? And you don't want to say he lied. Not when you do a rebuttal. Be like, he had false information in there that was untrue. So his premises that gave him to his conclusion was flawed, judge or whatever. So I'll say and the whole thing about when he said can tie buttons, tie shoes, button shirts, do zippers, or they say was able to get on and off the operating table, the examining table without assistance or without difficulty. And you say, but he wasn't even in the room. I was by myself and I struggled and I got on and he just came in and I was up there. So that I think is an unsubstantiated statement. So I always ask them to look at stuff like that because that's wrong. It's wrong. And it's meant to show that you're that physically able when maybe you're not. Be nice to that printer. Sorry. I got a person in here using the printer. Get back to work. Sloth. Just kidding. The printer's acting up, I think. I think it's offline or something. It was doing that to me yesterday. So I'm going to have to, I think I probably have to turn it on, turn it off. That's what seems to be let the printer reboot. I have a big, huge laser printer. Very expensive ink, but you don't have to change the ink and nowadays almost never since we do so much electronically. The printing 20 years ago, Shana, it would bankrupt me. It was a real struggle because the ink was so expensive. It's better times. It is great times to be a Social Security disability representative, I think. Do you agree?
I do.
Yeah.
Glad I looked into it and finding it.
Yeah. Ricardo says it's an old mess. Yes. If you're talking about the SSA, the old processes, they're getting adjusted, but it takes time, KU Thunder says, hello, Shana.
Hi.
JC says, if one goes back to work, what's the best way to report earnings? 800 number, field office. What do you think, Shana?
Trial to work programs. It's got its own problems. I just
Go ahead.
Then you don't need to report it. But if you are going to go over and do the trial to work, then I guess I'm not sure how you report that actually.
I will. This is the way would be my take on it. I like everything to be in writing, so you have proof that I got it. No matter what income you're earning, unless it's hobby work and it's definitely under SGA and it's under 10 hours a week or something. I mean, hobby work though, which means kind of sporadic, not regular hobby of 10 hours a week. That's really more of a job. I would report it, particularly if it's self-employed, because we're so able to fudge our numbers. I mean, Shanna and I are not, even though we're self-employed, because they give us a 1099. But for people that are not 1099s, that kind of work, I would report it so you cannot be accused of hiding activity that's bringing in income. And you probably send you an 820 or an 821. And so great, just fill it out and send it back and it's going to be fine. I agree with Shanna. If you can stay below trial work period amount, that's ideal, because then the work you're doing, they can't deny you on the basis of that activity because you're under TWP and you're still in your TWP period. Once you're out of your period, it doesn't matter if you're below TWP, then they can use that. So if you're always staying within your TWP and it never expires, because if you don't use TWP months up and you certainly don't use 9 in a 5-year rolling window, you're never going to pop out of your trial work period. And you got that protection. Doesn't protect you from other things like a regular CDR or something, but it protects you from the basis of your work being too arduous. I would probably report it to my field office, yes, but I would do it where I have proof that I sent it in, like certified return receipt. Or now, if you can get into your Social Security account or whatever, you can upload documents there still. Can you upload that? I would find out. And if you're not sure, then I would do both, but I would always make sure I would fax it and have a fax confirmation, and I'd probably send it certified mail to have the green card. Sounds like a pain. And it would just be to notify them of the fact that you're doing it. And if you say, I'm making 600 a month, or 1,000, which is still under TWP, it's with an employer, and I don't expect this amount to change. I don't think you have to keep reporting it every month. And what do you think of this? I have my opinion on this. Can you request SSA to periodically do work reviews, even if earnings stay below TWP? What do you think, Shana? You think they're going to go ahead and expend resources on that? Yeah.
Anything more than they have to. So.
Yeah. I mean, there's no resources to do favors. I mean, it's all about meeting the law and the requirements of CDRs and stuff, not to share those workers for free, for someone else to do a work review. I do know that you can get consultation on work review to have someone professional review what you're doing, what you're making, and how it all interweaves with SSA to see if it's safe, if there's something safer, the level of risk, all that. That's a paid consultation, but they're probably available. I know I do them, and maybe Shana does. I don't know.
I try not to deal with
outside
much
of representation. Ricardo makes an excellent point. If you do the work consistently, you will get positive results. That's exactly it. That's exactly it, Ricardo. And tweak it when it needs to be tweaked, because the world is changing. SSA rules change. SSA technologies change. When that changes, you got to kind of tweak to go with it, to know it and to use it and to make sure your processes align really well with it. That's probably what helped me the most when I started out totally by myself without a single SSD client. Just made the switch. I did cold turkey. I was really in tune and wanting to use the technologies that SSA uses and get everything copacetic in that way. And plus, being a solo, you have to streamline things to make them work best. And I didn't have like a fat, cushy company behind me that all I have to do is like think about SSD law cases and not think about how clients get me in for, like, I didn't have to think about anything efficient if I was working for somebody else. Then you're just like the hired help. But when you're running it and doing it yourself, you need it to be efficient, and you need it to be the way it's going to get the best results for the clients in the biggest numbers, of course. That sound about right?
Yeah. Fastest, easiest, and most efficient way to get the best results.
And you had a great perspective because you came from doing it from a firm. Like, you were their SSD, and then you found that was very lacking, and you're like, I got to go on my own so I can do it a better way. Is that what happened?
I actually started out as a paralegal in a law office, and then just found out that I could do it, and then got interested in it and started learning about it. Never really thought I'd do much with it, because back when I first fell into it, the cases were taking so long. So it was just impossible to make any money at it. And have your own business doing it. So I was doing it for a law office that I was working as a paralegal also for a while. And then I was doing some of these cases on the side, just as, side work, and I started taking cases in 2016. It was 2019 before any of them made any money from them. So there's no way that I could have done that. But COVID allowed the processes to move faster and the cases to move more quickly, and allowed me to be able to, in 2022, quit the law office and just do straight Social Security.
That's awesome. And did you look at the way they did it and go, I'm going to do it differently? Like, there's something.
Well, at the last office I was doing them, it was me. It was me.
But were you constrained by their budget for you or anything like that? Like,
no, it was basically they weren't going to do those cases. But the fact that I knew how to do them, if I wanted to do them, I could do them through them.
Oh, then they make the fee, and then you just get your salary.
Yeah. Well, there was an arrangement, but that didn't work out.
And then you're like, I'm out of here. Woo!
Something like that.
It's funny. That's awesome. Yeah, I don't have the perspective because I didn't come from it, where I was with a firm that, I was with firms, but that was doing New Jersey law. So I was never with one. There weren't that many then, but I think they did exist in the country, and I didn't know what they were doing and not doing. I mean, I've learned since a little bit more, but so I just had to use almost like common sense. Like, all right, I'm a solo. And like you said, you're starting out with, I had 0 cases. So I still was working on my other cases. I didn't dump anybody from New Jersey state law or anything. So that took me 3 of those cases. And then I just didn't take anymore. So then 2005, I never took another state-based case again. Everything I took was SSD, SSI. And I was trying to figure out how to get the cases, like how to get your name out there. And I was kind of creative with that. And that's when Google AdWords and stuff were where, bidding on a word like Social Security disability would cost you what your firstborn child. But how about a word like osteonecrosis? And this is a strategy. I think I told you about it. And I was like, that I started looking up less common ailments. I don't even know how I stepped into it. I think doing it the regular way, I got one case and I go, and I look and I'm like, God, that's cost 5 cents. Tailor my advertising to hone towards that. So that people trying to research osteonecrosis can know that a Social Security disability attorney here is saying that could be a disabling, blah, 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 blah. And that took off. And that was such a great help. And then everyone started catching on, the big wigs and stuff. And they can always outprice you. So thankfully, just connections and then clients, referring, former clients, stuff like that. And I had, some lawyer friends that do other areas of work, workers' comp and stuff. And now it's just a non-issue because then that pipeline just keeps growing, right? You probably see that with your clients, right? You get a lot of
a lot of mine do come from Google. I do come up at the top when they search representatives for Social Security around my area, and then after I get someone approved, I'll send them a Google review link and ask them to do a Google review. So that helps keep me up at the top too. And then others will come from word of mouth from my other clients or whatever. I just recently started doing some advertising on the radio, just mainly not because it's just so people get tired of hearing my name.
But they will forget it. And your firm has a great name. I mean, just your last name is awesome. Yeah, it's very cool. Let's see. Jones. I don't know if we've met on here, but your name sounds familiar, Rayford. Do you have to wait 75 days before you send a hearing date out? You want to take that one, Shana? Explain to me about the 75 days.
You don't wait a certain amount of time, but they will notify you 75 days before the date. I mean, you can get scheduled the week after if they've got one available and you're at the next on the list, but it'll be 75 days later before the hearing date.
Yeah. So let's say you apply for OHO and they could, in theory, we don't see this happen, but they could say the next day, all right, we've got a hearing opening in 80 days. We're going to give it to her because that's 75 days notice. There's also something called, I love the 75 days. I don't want that to change. I know some people want to get rid of it. I'm like, that's the time where the best work is done. I bet you the people that don't do briefs, they don't care about 75 days. They're just going to wing it anyway. I like the 75 days. You can fill out a 20-day waiver. And sometimes they automatically send it to you. And sometimes, I would say more often than not, I don't see it. I don't know why. Maybe because I would never agree to it anyway. But you can get a 20-day waiver that says they only have to give you 20 days notice. I mean, obviously you need just some notice unless you're not busy at all, right? You could have
I like to get updating records and go through everything and make sure I got my ducks.
Oh my gosh, yeah. It is time consuming. It is very time consuming. But you could do that 20-day thing, Rayford, if that's what you want. And if you have an attorney, your attorney, a non-attorney rep has to agree. I would assume. I would just, if my client insisted, I'd be like, well, then I'll say, see you later. Bye-bye. Because I want to do the work I do. I want to put in that time. I want it to be the strongest case. Not doing it, for me, would be a reduced strength case. And you're not doing that to my case. Even if you would do it to yourself. You're welcome, Furry. Jenny says, I don't have my therapist session notes. Good. My therapist does. They will not be getting them. Gotcha. Good. So now, actually, that's to your benefit, right? You're thinking because maybe your therapist notes are not so great. And she doesn't have to send the psychotherapy notes. She just has to send all the other notes. Maybe SSA shouldn't have allowed an ALJ to abuse them. You can't, it's very hard to prevent someone from abusing something because we don't have prior restraint around here. I mean, that's just an American principle. But then the ALJ will be overturned if what he did amounted to an abuse, a material one. The remedy is appeal. The remedy is not to turn the ALJ into a robot where he has no choice but to award everybody that comes in the door. You know what I mean? So it's not that the SSA allowed him to deny you. The whole point of him being judicious is having his own ability to make the decision. If he fails to follow the steps he's required to follow before making it, that's when you can bang it out and appeal. You follow? And get it reversed. Yes, you have a right to protect your mental health, and you're doing that, right? I mean, you can't change the law that applies to, the due process, but if your due process has been neglected, the judge didn't do something that gives you the due process you're entitled to under the law for SSD case, that's where you win your appeal. So that's the whole gist, right? And I think you did win your remand because the judge did do something wrong. So we don't want to harp on that anymore because now you've got your remand in your back and you have an attorney who I think you said is really good, right? Hits for Life is in the house. Nice to see you back again. Oh, I got to start blowing through these questions, huh? It's almost the 2-hour mark. So fourth ALJ, vocational experts stated that there were jobs available. Fourth ALJ. But after lawyers' questions stated none, applying in 2018, back surgery and over 7,000 pages of medical evidence, 45 years old with college. I don't know if there's, oh, hits goes on. Hold on. College degree, chronic bilateral radiculopathy, L4, L5, proven by EKG, chronic migraines, asthma, depression, anxiety, gastritis, used a cane for mobility and support, was just diagnosed 2024 with fibromyalgia. Sleep apnea is going on, and mild cognitive impairment. CE, physical stated, unable to do sedentary work. New judge, 32% approval. Cases remanded 3 times by federal. I don't really see a question in there, but I wish you the best of luck. Unless there's something you wanted to hit on there, Shana.
That's an awful lot of medical records, someone at age. So hopefully with this next one, you'll finally get it approved. That's a lot of remands also.
Yeah. Is that your third remand? Might be your lucky 3, right? The Roadshow's in the house. Hey, Stephanie. Lily's in the house. Yeah, your picture. See her picture. Thanks for your amazing lives on all things Social Security. Thanks to our guest speaker. Good to see you, LaRocha. LaRocha says, Shana, thanks for being in the house and your added expertise. Just so you know, LaRocha, it's Shana with an A, not Shannon, right?
Yep. I'm glad to be here.
Just to be clear. Yeah. It's been too long. Vicky Meyer says, 54 years old. I've been diagnosed with severe bilateral osteoarthritis, x-ray evidence, doctor prescription for crutches, less than sedentary, not much treatment history due to no insurance. I'll take a stab at. There's no question there.
Without the documentation, it's going to be very, very difficult.
I agree. Ick Meyer, what's with the Medicaid? Have you applied? I say this to everybody. Have you applied? Because that is for when you can't afford to buy insurance and it's not provided by an employer or whatever, or a spouse's employer. I've had so many people, Shanna, I don't know about you, but who didn't have insurance and they're like, but I'm disabled. I'm like, I get it. And I said, have you applied for Medicaid? And they're like, what's that? And they really don't even know. And I said, if you're poor enough and you're not working, so you might be, and if you don't have a wealthy spouse pulling in the bacon, yeah, go apply. You might be surprised. And then you have to use it robustly. I've had people that have gotten it and then they didn't really use it. Well, the appointment wasn't for 4 months. I'm like, that's 4 months. It was 4 months ago now. Like, you get on there and you make every appointment and you never leave a doctor's appointment without setting up the follow-up appointment. Be the squeaky wheel on your own behalf at your doctor's. And try to take all of the covered remedies they offer, like PT and all that stuff. I mean, you got to be the squeaky wheel, all these people are working very hard. Is that printer working? Their job isn't necessarily to be your counselor. Their job is to, when you make an appointment, and they're not, sorry, we got to fill the printer. They're not going to be able to know your personal situation. I just think we're expecting too much of other people whose job is to say, be a medical assistant, to then also be, being our personal counselors to get us appointments and treatment and all that. I think it's just not realistic. What do you think, Shanna?
Find ways to do it. Some offices, I don't know, their income issue, situation. Some offices offer a sliding scale. If you're out of the, financial range for Medicaid, you may qualify for that or something. Without documentation, it's just not going to be.
You have to have. I mean, I'd like to see you with MRI, P. Meyer, not just X-ray.
Yeah.
Are the crutches for a permanent assistive device, which is going to hurt your armpits? God, when I had to use them for a week, they were killing me. I like MRIs. And how is your back? You're 54.
Yeah.
Usually there's something in the back too, not just the. Well, you didn't say exactly where it is. Back, knees, whatever. I just think you have to make getting that treatment your full-time job.
Yeah.
Whether that's, and I've said this before, so I'll be a repeat person here. Some people do a very mild, easy, not high-paying job of, say, 8, 9, 10 hours a week. It is not inconsistent with the limitations they've claimed, to get the money. So let's say it's $100 a week, $400 to pay the premium. Now they have insurance because they couldn't get Medicaid because something, whether it was they have a spouse who makes just a little too much or whatever. That's an option too if you're not completely an invalid, you know. Something that's, 2 shifts a week. Just don't go over SGA, and ideally you don't go over TWP, right? But definitely don't go over SGA. But that's a way to get over it. When there's a will, there's a way. I'm always trying to think of the creative ways to.
Yeah, sometimes you have to.
Yep. Kimberly, and it'll only be temporary because eventually once you win, then you get Medicare. Can I still apply for SSDI when I only have the hospital records from my stroke, which includes my CAT scan and my MRI? Would you like to?
I mean, you can apply anytime, but whether or not it's going to do any good is a different story. Because like with a stroke, have to be able, there's like a recovery time. If did it cause any residual effects, whether walking issues, speaking issues, mental health issues, like what did it cause? That has to be documented and that kind of thing. Other than that, I mean, you can apply though, but.
Yeah, you can apply at any time, exactly. But I would think you would probably need more. We don't know what your vocational profile is or anything, obviously, Kimberly, but the hospital records, you eventually got out of the hospital. And if there's no evidence to show your limitations now from that stroke, at all, you could be back to normal. I mean, for all they know. So, and then SSA always prefers to see durational, ongoing, not just like, oh, I go to the doctor and he said I got left-sided weakness. All right, well, you don't need the hospital, obviously, and you have left-sided weakness. So that doesn't mean you can't do sedentary work or maybe even light work, with a cane. I mean, because that counts. Dimple in the house is sending messages 5 times a week. Is that all? LOL, guilty as charged. You're not quite that much. And I love it. I mean, this is how I make friends.
I have know that they're doing what you need them to do while you do what you need to do. Yeah.
Well, Dimple's one of them, and I love it because aside from the fact that I like some clients I know they're doing everything that makes it as strong as it can be by getting us like reporting like every visit. Like they follow what our ideal client does. Yeah. And I see these people get out on initial and recon probably 4 times as much as the national average. So, and not have to go to a hearing. So I love that. It saves me hearing work. I mean, if on the selfish side, it saves me a lot of
of work.
Yeah. And I just like to see people get out sooner rather than later because I know it's really stressful, and I care about their little hearts and their stress because that kind of stuff is going to, really hurt us in the end. So I love that. And then sometimes it's just friendly stuff. So that's all cool too. And I have many a post-client friend around the country now because we'll do those little chats, even when it's not, there's always the business part, but then there's nothing wrong with, and not everyone can do that because not everyone has that personality or that desire because I could be very annoying and quite the nag, right, Dimple?
Me too.
Half Point says, have to say your system works very well. It does. I love it. Rob the Great says, I'm receiving short-term and long-term disability payments from employer benefits. Does this impact my SSDI application? Would you like to take that, Shana, or
not? Essentially, no, it doesn't. I mean, I know a lot of those companies want you to pay back sometimes some of the money that they gave you during your waiting period or whatnot, but other than that, it doesn't actually affect that claim.
That's right. I've had people say I didn't file because I had a long-term disability. And I'm like, that was a huge mistake.
No bad idea.
Yeah. And let me just tell you guys, one of the consequences of not filing for SSD because you either have workers' comp or long-term disability, 2 different issues. LTD is not a problem for us at all. Workers' comp is a pain in the rear.
Can be, yeah.
It does throw some monkey wrenches, but we still take them. I'm sure Shanna does too. If you don't, and you don't go back to work in the same at all or in the same level of income as you were doing before, you will have, number one, lost your ability to file for SSD because your DLI is going to run out. And even if you go back to work a little bit, but you didn't make it an SSD related work and you didn't clinch an SSD case, your retirement, depending on your age, is how badly it's going to be decimated because now you have 0 years of income at 12 zeros a month, at 12 monthly zeros a year, averaged into the top 35 years of earnings. And your estimate, when you were looking at your estimate, if you ever do, for what am I going to get when I retire? Or what would I get if I got SSD? That, if you read the small print in there, it says this is based on the top 35 years with the assumption that the most recent year you worked is going to be repeated until you're 62. So if you're 50 years old and you don't continue what you made at 49, and maybe that was a high year because you've been working for, 25 years. By the time you get to retirement and you never filed for SSD, maybe you had a wealthy spouse that could afford to keep you in the style to which you become accustomed, or you're relying on the LTD. You're like, I can get by on this. Not wise, because now that estimate you had assumed that you're going to be making that $70,000 you're making for the next 12 years, and it's going to be part of that top 35 years, knocking off your bottom 18-year-old income years, which are, next to nothing. At least they were when I was 18, for me. And now you have a completely unrecognizable retirement amount, because now you have 12 years of zeros that replacing what they thought was going to be 12 top years. It is, if you're like 61, 62, it's not probably a big deal. But if you're much younger than that, it's just a thing of math. And it's, even if you're not going to see anything, so you're going to get $50 a month in the end between the offset with SSD and LTD, do it anyway. Because that LTD, once you're of retirement age, I don't believe the LTD can have that offset. So you'll be getting both now if the LTD continues forever. And I don't know what your policy is because they're all different. But you want to protect that highest SSD amount, so you're going to get it later, because it's no longer SSD, it's SSI. That's a fun fast fact that I share to everybody, Shana, because
don't wait, just apply regardless if you got money coming in.
Yeah. I mean, it doesn't mean you might not wait a few months in case that's a better strategy for filing.
Yeah.
But don't blow off the SSD because of LTD. Jen asked, thoughts on crying at a hearing? I listened to the recording of my first hearing. I started crying a lot sooner than I remembered it happening. For mental health case, it's giving unstable or showing unstable. I have thoughts on that. Shana, do you want to provide your opinion?
Go ahead.
You want to pass? If you are brought to tears at a hearing, and that's part of your impairment anyway, easily brought to tears, I say then it's not bad. Obviously, you don't want to make up the tears, but if that's something that you're prone to do, I've had plenty of clients who, and they are probably more physical, less mental, but a little of the mental, whereas, maybe you consider your case mostly mental. It was not taken badly by a judge, particularly someone who's dealt with chronic pain and stuff like that. But if your medical record, if it's a mental health claim primarily, and your mental health records all speak to how you are, what is the expression? It's like prone to crying, like you can't control that emotion that causes it might be like dysregulation. Yeah, and it specifically says you were prone to crying in a situation where most people that don't have your impairment. I think it can't hurt you, because that is a stressful time of hearing. Even if you're angry like you are at the system and stuff like that, you've been dealing with your pain and your struggles for this long, and now someone's listening to you. I almost equate it to this, and it's different, but just bear with me. I was thinking about this like 2 nights ago. Did you ever, Shana, everybody might have. I remember being younger, and if I played a lot of sports and stuff, and if I ever got bopped in the nose, say, or somehow hurt, not chronically, but like an acute pain at the time, and you're on the ground and you're toughing it out, you're being tough, you're just clinging to whatever hurts really, really bad, and the second someone would come up to you and be like, oh, Stephanie, are you okay? And you look up and here you are tough, and you're like, and you start crying because someone's showing kindness when you're just trying to get through this pain. And that was purely just like, I don't know. And then a similar thing might be where it could be a sadness, and I say this from a person that hasn't fortunately had to deal with mental health illness or anything. But you go through a bad breakup, and goodness knows, guys, I didn't get married till I was nearly in my mid-30s. So suffice it to say, I dated a lot of frogs, dated a lot of nice guys too. And then, at times when my heart was broken. And I remember, you're toughing it out when your heart's broken and you're trying to get through life, trying to go to work, you're trying to do blah, blah, blah. And you don't really want to talk about it. Like, I wasn't the type that would want to talk about it, because I could then I'll get emotional, right? You're just trying to get through it for enough time where it's no longer so painful. But when someone would ask you, how are you doing? You could feel yourself welling up, and the struggle was to not, because it's like, no, I don't want to be crying. I cried when it happened. I cried in my own private room. So I almost feel like when you're in front of someone who's asking you about your parents, it can be, and particularly if you've got crying kind of dysfunction anyway, I think that would be something that I would expect someone to do.
Yeah, what I tell everybody is, obviously we don't want any fake crying, but what happens is we get into the hearings and the emotions take over, talking about the things you can't do anymore and explaining your daily activities and things like that. So I tell everybody, like, when you start feeling emotional, your first instinct when you're around other people is to hold it back. and to keep it to yourself and act like you're okay. I always tell my clients, don't do that during the hearing. I'm not saying fake cry, but let it happen. The judge needs to see that how much it bothers you during that time that we're talking about it. So
yeah. And it will show that at the very least you can't keep the composure, the professional composure that would be expected for normal to low end stress things at a job, perhaps.
Yeah.
It just, I think getting through a hearing doesn't mean that you don't have the impairments that you claim, but why hold back evidence? Why struggle so hard not to, so I don't think you should worry about that, Jen, if you do it.
Yeah.
If it happens, it happens a lot. I mean, and I'm talking about for the physical people, but a lot of times, I would say more often than not, way more often than not, my physical clients, they've been dealing with this for so long, and it's scary because usually we're starting to get older, and everyone worries about mortality too, but like their life has changed. The pain is that's a former client calling me through, but I can't talk to you right now. Come to the live stream, my friend. Goodness gracious, you should be at the live stream. I'm gonna have to. That's funny, right? From like 2 years ago, but we're friendly online and stuff. Yeah, I don't even know where I left off, but the paying people. A lot of times you'll start getting, they call things like, there's something called adjustment disorder when you're having a hard time adjusting to the fact that you're no longer the breadwinner. You're no longer this. You guys, you can't give your kids what you were giving them before. It could be like marital relationships or significant other relationships are now going sideways because of the pain-related symptoms. So I see people develop anxiety over their condition and depression. I would say more often than not. And they might have had an underlying propensity for that, but they didn't have to treat for it or not much or whatever. And now it's like, life is so changed, right? Vin Jones. Hey, are they changing? Nice to meet you, Vin. Are they changing the day they pay you for Social Security disability benefits this month? Not that I know. Why? Did you hear something? It's usually the Wednesday that your birthday lines up with. Obviously, if there's a holiday, that can change it. Like it might stem over to a couple days. Larocho says, do you have to give consent before taking medications? With Maha Progress and Casey Means as Surgeon General, do you have to consent? Do you have to give consent? What do you mean? It's time to rethink healthcare. Functional medicine is the future of true wellness. I don't know the answer to that. That's outside of my pay grade. Do you know what she's talking about? I mean, you give consent to treatment. We all have to sign that stuff when we go in the doctor's office. They prescribe you something. You pick it up at the pharmacy. You choose to take it or not take it. I don't know. Who are you consenting to? Yourself? I don't understand but I agree with you. I think we definitely need to rethink healthcare. Atrocious. Oh my goodness. It is. I don't even like the system. And my daughter just had an issue, and it might be a chronic one, which would be unfortunate. And just getting appropriate care and anyone to pay attention. I don't know. It's just horrible. It has to do with like stomach issues. But it's like, I just find that our medicine has gone down the tube so much. LaRocha says, I prefer functional medicine because it focuses on root causes and overall wellness rather than relying solely on, I'm with you. There are safe alternatives that work for many people. I agree with you. I will say this. I happen to think functional medicine is the bomb. From a legal perspective, if it's not MD or DO, it's going to weaken the case. It just is, because the law is still the law of what the evidence is that, can be considered for certain parts of what you need to meet. And it's a struggle. I have a client who does functional, and I would like to see, I'm always nagging for, more therapies because I need something. I mean, there's a reason a lot of people don't take medications when they're prescribed, and it's because the side effects are horrendous. And I think that's true of most medications. And I get that entirely, but they need to be discussed with the doctor why I'm not taking XYZ medication. I need you to do something more homeopathic for me. And I'll tell you, it's not really taken well by the SSA or even the judges. So I have had them, I have won them, but it was not, I felt like it was, when I took the case, it was one of those cases that you took because the person's disabled, but you don't think they're necessarily going to win no matter what you do. But I thought they deserved a chance. And it turned out being wonderful, but that's not really, I don't necessarily expect that, even though I take those cases. What do you think, Shanna?
More complicated.
What's that?
It definitely makes it more complicated to get them approved, that kind of thing, because they assume that if you're in bad enough pain, you'll do whatever the doctors say.
Yeah, I would add this. LaRocho, if you are going to be using functional medicine, which is what I would want to use, and I wouldn't mind getting a functional medicine doctor right now, just for my, I don't really have a big problem, but I don't know if my health insurance will cover it. That's a problem. At least try to get the diagnostics periodically to show that that condition exists and you're not just treating naturopathically for an alleged thing. Because a lot of those claims, you know, pain is subjective, fatigue is subjective. So you almost have to really work twice as hard, I think, on your case to have still what's probably going to be less evidence, but at least it might be, you know. Ringel says maybe x-rays. I forget what the question is, Ringel. Chris is in the house. Mr. Montana. Hit the like button, guys. Yeah, come on. What is it, Christina? I don't think she's here, but she always says like, share, subscribe. And everyone says, you got to say that out loud. Okay. Thank you, Ringo. Gosh, guys, we're way over time. And Shiloh, I know we didn't get to all your function report questions. Sean Bailey says, I'm 54 years old. Recent visual test showed fields of 15 degrees in both eyes. What should I do? I don't know. Are disabled or not disabled? That's the question, right?
INC, I'm
That,
familiar with that listing.
yeah, I was going to say, do you need a listing or not need a listing? I mean, I don't have them all memorized to numbers either. But if you do, and at 54, you probably have other problems too, Sean. If you want to reach out, do that free eval at joydisability.com. It's up in the link at the up top left, and I'll take a look at it for you. If it's something you're thinking of doing and just want to see, you could try to pull up the listing. You can even bring it to your ophthalmologist, I would think, and you could say, yes, this is met because of XYZ. And you know, you could even file solo if you think that's the case. I will just say, I just at the hearing in January, there was a young person who was at hearing when they came to me, and he felt that, you know, it's a listing and we should went on listing, but he'd been denied twice by SSA. And we took it to hearing, and he's definitely, I mean, he had to like peer, you know, go right up to the screen to see the judge. It did. You know, like he was disabled for other reasons. And in fact, we did win on a listing, but for a different listing. But that's what my whole point is. I pushed for the listing for visual. That's not what there was a medical expert at the hearing, and he was a sweet old guy. And he was focused on this other listing. And now I feel like he could have met both, but I'm not going to sit there and make an argument when my guy's going to win. You know, not like his evidence is going to go away. Anyway, I'll take a look at it if you want. And I'm sure Shana would be happy to as well. La Lulu says, hi, La Lulu. SSA rents space for contracted medical examiners to conduct the CEs in chiro offices. Yeah, but she said he had a CE with a chiropractor, especially on weekends. Well, that's funny because most of ours are just always in the doctor's office. The regular guy, like he's got his own office. There's no reason for him to go to someone else's office. Could that possibly be the chiro connection? I don't know. I didn't know that SSA did that. What you're saying? Are you familiar with that?
Yeah, they do. I don't know that SSA rents a space, but that person may do it. I don't know how they do it, but
the guy that wants to be paid by the SSA, so
yeah,
he probably doesn't have a big caseload of his own. So he's like, maybe he's a guy starting out on his own, and he's like, I'm going to do SSA work, and then he needs an office. He doesn't even have an office yet because I don't know. That's possible. Yeah, I think I've heard of that. And thinking back, La Lulu, I mean, I haven't heard this, but it stands to reason that let's say there's a rural place that there's no doctors willing, because a doctor has to be willing to do CE exams. And they don't necessarily pay as much as maybe it would be worth the doctor's while or whatever. I wonder if they do take some of the people they do have and say, all right, we're going to rent out in Timbuktu here because these guys, they shouldn't have to drive more than an hour to a CE exam. And so they want to put a CE closer. That would make sense to me because they need to give every claimant the opportunity. And a 3-hour drive is not an opportunity for most disabled people. I mean, 1 hour is hard enough. Merit exposure. Merit exposure says, I reached 100% permanent and total disability yesterday to the VA. Thank you for your service, Merit. And I have a scheduled CE physical exam scheduled for the 13th of April. How can I utilize my recent VA award? Thank you. First of all, well, Shana, do you have any thoughts? Right.
I do take those kind of cases, but I hate them because
he wants to know how he can utilize his recent VA award.
The print, the letter that they get, that's your best evidence because most of the time VA doesn't want to do any more treatment than they have to with the people. So there's not as much medical evidence unless they've got a secondary health insurance, you know, to pay for stuff. So it makes it a little bit more complicated. The letter that it outlines the award and the reasoning behind it, that's the best thing that you can do is send that in.
Well, what I would do, and yes, that obviously goes in because plus it's going to get you on the priority list, at least for timing, for what that's worth, which might not be much. All your VA records should be gotten by the SSA anyway.
Yeah.
You know, like they do a HITMR and get them, and just make sure that they get every office. Like if you just go to one VA, it's kind of easy to tell. I know there's some like clinics out exterior that like their records don't show up in the VA, even in the veterans access, which is weird. And they don't go through that what is it, JHIE, and it can get a little tricky. So the basis gets in, I think, but then sometimes these tangential things don't. So you just want to make sure all the medical records are going. The award, yes, it's important, so you get that prioritization, and it shows that it doesn't show that you're disabled under the SSA rules, but it shows you got some significant impairments. So that kind of starts, lays a level at least, and then you just got to build it to the rest of it. More stricter definition of SSD. You're probably aware of the difference. I know I have a video on that, Merit, where explaining why can I be disabled vet 100% PNC and SSA denied me. Because one, you have to be able to work, and one, you have to be unable to work at any job that exists in substantial numbers, and the VA doesn't require that. And in fact, you can go out and get a job, and they'll still pay you. So that's it in a nutshell. But make sure that they get all those, every single office you went to. Don't just say like on your 3368 when you apply, the VA in West Virginia or whatever. If you go to different offices, I would definitely put them in there.
Yeah.
Each address separately, because you want to make sure they get all those records, because they don't always all come down on that big HITMR they do. Is my understanding anyway.
Yeah.
I know sometimes people are like, I'm VA, I'm just going to say VA. I'm like, to your own demise. That's not going to be helpful for you. You'll find out when it's denied. So you just got to do your best. Let's see. Michael Ruth says, live in Massachusetts on SSDI. Every time I get a COLA, nice to meet you, Michael, increase, the state deducts it and more. Why aren't the states adjusting so we keep that money? What are you talking about? Are you sure the state? What do you mean the state? The state can't adjust it. You know what he's talking about? Unless some states, most states have a supplement. Nah, that's for SSI. You said SSDI. I scratched that. You're not. It's not getting adjusted for that. Your Medicare costs might go up. So a lot of times we don't actually see the COLA because it actually gets taken by the Medicare premium, because that went up. You follow? And there's usually, for most people, I want to say hold harmless rule. It's where the cost of Medicare premium to disabled people or retired people cannot go up. Even if it goes up more than the COLA, they cannot make you pay for more than what the COLA would cover. It's a little hold harmless. In the end, it's helpful, but it's not still entirely holding it harmless, because now you're not actually getting a COLA for the other things that you have to pay for in life, like gas and food and everything else. And then there's a certain portion of retired people that hold harmless doesn't apply to. If they are not collecting Social Security retirement, but they're on Medicare, that won't apply to them either. I do not believe. You got to already be collecting for it to hold you harmless. You don't know anything about that? There's no state deduction. They can't intervene with Social Security unless you have like a lien or something. Like, did you not pay state taxes or something? So I don't know what you're talking about. You don't know what he's talking about either, Shana?
I can just assume it's like the insurance, deductible or not, or whatever, that they got to pay for. It raises with COLA too, so it kind of just takes it all away, like you never got it in the first place.
Yeah. All right, I'm going to try to skim through these and just get to ones with questions. Half Pint wants to know, so you don't think that working through the Ticket to Work program could jeopardize, now you said Ticket to Work program, Half Pint, that's not the same thing as TWP. Could jeopardize our SSDI even if it's under the allowed amount. I think people confuse Ticket to Work program with TWP, which is funny because it has a T and a W and a P in it. Do you want to take that, or any thoughts on that?
You probably know more about that than I do.
Ticket to Work program is what you do when you're trying to get off of SSD by working over SGA. And it's a period of time where they help you do that, and you have certain protections. It's through like designated Ticket to Work providers and stuff like that. That is when you want to get off SSD. You want to be self-sufficient. You don't want it anymore. So clear big difference there. I think what you're referring to is someone that wants to work, but no plan on getting off of SSDI. They know that they're disabled and not able to sustain full-time work, and they want to stay. We have a TWP amount, which is what keeps you in the trial work period if you don't go over it. more than X times, it's a little bit more protection than when you're not, if you're outside the trial work period time. And I have videos on all this, guys, under this playlist. You know, if you're like over TWP, let's say you're totally outside the trial work period. Now you're just working under SGA for the rest of your life or as long as you can or whatever. You are subject to CDRs, which everyone is anyway, even if they're not working. And they can consider the kind of work you're doing. So if you're baling hay for a farm and you have a bad back, it's probably not going to look too good. So I'm going to assume when you said ticket to work program, you didn't mean that. And you just meant like if you're working under trial work period amount, and you're within your trial work period, you don't think that's going to jeopardize our SSDI when it's under the trial work period? I do not. As a general rule. Shana, well, now that I put it that and framed it that way, because she had some miswordings here. Working under trial work period itself is not going to hurt you. They have to find you medically improved through a CDR, a separate CDR.
Yeah, as long as they stay under the SGA limit, then they should be fine either way. But
well, except if they're not in their trial work period, the SSA can look at the kind of work they're doing.
Yeah.
So when you're in the trial work period, they can't say, well, look at her. She's being a lawyer for 5 hours a week making, it's under trial work period because she don't get paid much. But that kind of shows that she had a cognitive problem before where she couldn't focus and think. And, right now with trial work period, they can't look at the kind of work you're doing to determine that you are no longer disabled. When your trial work period is over because you worked too much over the trial work period amount for too many months, now your barrier is SGA, but now they can do a CDR and they can look at the kind of work you are doing because it's no longer protected by trial work trying. So that's a real important distinction, guys. If that's why it is beautiful to stay in a trial work period, not just SGA, particularly if it's going to be higher end work, you're keeping the monies down, but if you're not going to be in trial work period, they can look at how, and it depends again on each fact of each case. Like I just gave an example of someone doing a high-end job, who used to do a high-end job, making under trial work period, but their impairment was, say, they were in a coma and they had to learn how to think again. Well, now they're clearly learning that, you know what I mean? So their work is actually allowed to be used as evidence. They also have to prove it by the medical evidence, though, too. So anyway, that gets a little complicated, right, guys? Because you have to make sure you're not talking about your ticket to work program, totally different, and then know the difference between trial work period and when you pop out of it. And now you're in your 3 years of extended period of eligibility. And they're like two different animals. Joel's in the house. Hi, Joel. Joel says, good morning. I'm just beginning the SSDI journey. Fun, Joel. Filed initial application 2 weeks ago with spinal stenosis, osteoarthritis as my ailments. I'm 59 years old, using an attorney. My surgeon is filling out the RFC. Awesome. I think you sound like you're in an excellent vocational profile, and you've got the physical problems which keep you in the grid thing. Past relevant work will be important. Obviously, your attorney knows all about this, obviously. So, but do it right, and it might just be what you need. But I think the biggest question unspoken is your past relevant work. That's that prong of the grids that can hang an older person, particularly if they had high skilled work, and they have no mental health or cognitive problems at all. No diminution in the ability to concentrate and stuff like that. Joel actually had a question. Sorry, Joel, I hijacked you. Question is, how long can I expect before my case gets going, and when I can expect a determination? I have a ton of medical records, etc. Well, that's a loaded question because it all depends on so many things. Anna, thoughts?
Already working on it, and then they'll send you some forms to fill out and request your medical records. Depending on that, whether they'll send you to a CE appointment or not, it's a process. It takes a little bit of time, but they're already working on it.
Right, for sure.
So 2 weeks ago.
Okay, yeah. So as soon as they get it out of the field office, Joel, which sometimes can take a number of weeks, and they connect your lawyer, and sometimes that can take a number of weeks, and they don't always happen at the same time, which is really frustrating. You're going to be at the DDS, and that's when all the medical workup starts. It doesn't start when it's still in the field office. That's like a nothing burger. And we're always trying to encourage them to please process those faster and get it to the DDS. And then your attorney, once he's connected, can see your electronic file, and he's going to know what medical evidence was received and put in there by the SSA. If he puts anything in, which you got to be careful about because you don't want to send duplicates. So you try to give the SSA their opportunity, not to mention they pay for it if they do it versus you, the claimant, paying for your medical records. Yeah, you're on your way. Barbara Gillespie, nice to see you again this week, Barbara. I was told they were sending my medical records to be reviewed. Who's that? I guess I'm still in stage 3. Oh, I think maybe what they're saying was that the DDS that said they're sending it to the medical expert that they have to look at them and figure out your RFC. That would be a stage 3 thing in that area. How do I know if they received all my medical records? If you're unrepresented, you're going to have to ask the adjudicator. I'd call the adjudicator. Does the grid matter at this point? That will matter on whether you're over 50 or under 50. Any thoughts there, Shana? Any refutes? Anything I'm not thinking of? I'm sorry. It takes a second for your voice to pick up for some reason. Can you repeat that? Because if you keep it short.
Yeah, I agree with you.
Yeah. To call the adjudicator if she's not represented?
Yeah, because that's the only way to know what they have.
Yeah. If you were represented, then your representative, if they practice more than minuscule, will be able to go in and see the electronic file and see everything that's been received. But if you're self-represented, you don't have that, obviously. But you can call the adjudicator. Chenmi says, I won the remand and I haven't. Yeah. Chen's unhappy with this ALJ's behaviors. Hi, KTN. What do I do if doctors are not writing notes? Also, what if they tell SSA you're not disabled? Jenna, you want to take that?
Find a new doctor. There's doctors everywhere. You've got some that thinks everybody should be on the job the day they die, regardless of what's wrong with them. You don't want one of those doctors. You want one that's actually going to help you and listen to you. So go find another one.
I agree. Nothing wrong with changing up. Ick Meyer says, I could get you in here. Just recently got Medicaid and started to get treatment. Good. Everyone who does not have health insurance and it's because of money between you and spouse or whatever, I would do it. I would do it in a New York minute. It won't be forever, that Medicaid. So Ick Meyer also says he or she just filed for SSD in February. So you're very early on in the process. Sly says, just got my denial letter 5 minutes ago. How do I go about getting legal help and an appeal started? Yeah, I would suggest you definitely get representation. I know, you can fill out one of our evals. I can't say whether or not we have, opening your category, but you can also, ask Shana to take a look. She probably, do you have like an intake thing or thing they go to provide information?
I have a contact form on my website and put your phone number, email address in, and we'll give you a call. But I am accepting new cases. We'll talk to you and go from there if that's what you want to do.
Yeah. Mr. Pet Mom's in the house. Finally got my back pay after waiting 4 months. Good. We talked about this last week. 4 months without back pay. I said, that's a long time. I think you need to be the squeaky wheel. And I think Mr. Pet's attorney had been paid, but not, and sometimes those can go in different order, right? The representative can get paid. However, 4 months is a long time, I think. I contacted my congressman and I'm hoping he has something to do with it. I wouldn't be a bit surprised. Did you do that after we spoke or had you done that before then? Just curious, because I think I said that last week. I'm like, call them, and if you tried that and it's still not good, sometimes you gotta reach out to the congressperson. You do it sparingly, but I think that's one of them. Escobar is in the house. Nice to see you. Good afternoon. What is the possibility to win SSDI for PTSD, being a veteran with 100% for PTSD and Philly pay? Yeah, I have some thoughts, Shannon.
It depends on the treatment you're still continuing to get, because the rules are different for VA versus Social Security, and it has to be documented treatment still, not just the approval. And most a lot of people stop.
Yeah, I agree. And because the PTSD they awarded you did not say that you are unable to do all jobs and every single job, right?
Yeah.
It just says for their definition. Also, I think much will depend on so just to add this to it, on your vocational profile, over 50, under 50, you have to make it that black and white. And do you have physical problems? If you're over 50, if you're under 50, you just have to be wiped out by the PTSD. Like you can't do a 3rd grade job with no stress and everything else. It's like really a big burden. If you're over 50, you need to have physical problems. And I'm sure if you're over 50, who doesn't have some degenerative changes? And that's what you really have to go to town to while continuing to treat for your PTSD. And say hello to Philly, the city of brotherly love, or so they tell us. I see a lot of crime, so I don't really go to Philly. It's about an hour and a half away from me. Simple says, thanks to treatment options they have copay assist, which still counts against my deductible. Sweet. Christina is in the house. Christina, I don't know if you were here before. I mentioned you. Where are you? Hello, friends. Please share the live stream. That's a great idea. Mark Benson says, I'm going to start crying if the ALJ gives me a denial letter. Oh, Mark. I know we spoke last week, right? Hang in there. Persevere, chin up, and just make sure you always know your path so that you know whichever result you got, what step you're taking next. And if you don't have a path because of maybe no more insured status, maybe think about whether or not you're going to be able to change that. I'm always talking about that DLI. But keep positive. Regardless, keep positive. I'm seeing the comments, guys, which I will review more later, but I'm just going to try to find the questions because we are We've been troopers today, Shanna and I. It's pushing 3 hours. Usually it's a 2 hour limit, Shanna, but I have trouble pulling myself away if there are questions.
I get it. I understand completely.
And I'm so sorry, Shiloh. Shiloh, I don't know that we'll get to your function stuff, which is way up above. But if you want to put them in like a post underneath one of the videos, I can try to get to them there. What do you think? Okay, this is a conversation. I'll let you guys continue your private conversations. Well, private public conversations. Biscuit is in the house. Wait, no, Michael Ruth. Oh, here's what Michael was talking about. State deducts SNAP, kicked off medical soon due to cost of care. Okay, so the state does not touch your Social Security. It just says you're no longer poor enough for SNAP. So that's a whole different animal. And it's true. When you make more money, you're going to have probably less welfare benefits that you can take from others because you have your own income, right? And yes, you're going to be kicked off of Medicaid because you're now going to have your income might be too high. This is one of the things I think is a big problem. Not so much the SNAP, but I'm going to just address real quickly here that 2-year window before Medicare kicks in, Shanna, for many people. If their SSD is too high, and I'm not talking about a $4,000 a month taker. I'm talking about, I don't know, maybe even like $1,500. They're going to lose their Medicaid possibly. And now they can't really afford to go out by their own on their $1,500. So I think that is such a problem. I think there needs to be a solution for that.
Yeah,
And
the
again,
2-year gap is awful.
Yeah, in those situations, a practical solution for those that can do it is that part-time job I was talking about before. It's under TWP and under SGA and doesn't belie your disabilities to make just enough money to buy your marketplace policy or whatever, Obamacare or whatever you're gonna buy. I do think that's a problem. I think it should be. I would like to see the Medicaid have a sliding scale. Like, well, now you have. It could even be like, I don't know. It's just got to be a way where you can keep it, but you're going to pay for it, And then when your Medicare comes in, which you'll be like so grateful for, then you're gonna have your premiums, but that's a whole other story. And you might not have like Medicaid paying those premiums because maybe it is too high. But at least you'll have, for $200 a month, you have Medicare from your benefit versus nothing right now, no options. Yeah. And it's funny, Michael, did you say you were in Massachusetts? I would think that's one of the most liberal providers of benefits, welfare benefits of all, maybe. And you're saying that your SSD is too high. Well, then maybe it is high. Maybe it's beautifully high. Again, I'm a protector of welfare benefits because there has to be a limit to how much income we have and still expect to have our working counterparts, many of whom can't have any savings whatsoever because they're paycheck to paycheck, paying for us to keep all of our benefits, even though we now have $2,000 more a month than we did before. I'm very protective of those funds because they are paid for by people who can, are just trying to get by in life as well. They're just able to still work to do it. So it's one of those things that I see both sides. I would like to see a little bit of a sliding scale with these things, maybe that we're not seeing. So that maybe, Michael, instead of them kicking you off totally, it's like a sliding scale thing, particularly for the health insurance for that 2-year gap. That's so troubling to me. Yeah. Biscuit, I'm sorry I had to put you off there for a second, but then I saw Michael Ruth actually was kind of talking about things to talk about. They're not having a private conversation. 63-year-old disabled RN, registered nurse, labeled, I'm confused, deceased, all assets seized by authorities. I'm not going to know anything. I don't even understand what this is. I'm sorry, Biscuit, I don't understand. But I see something adjoins a county cemetery. Quite frankly, I always wanted to live next to a cemetery. I thought it'd be very peaceful. I know. I do like to walk through them and some of the older ones and read the tombs. And you almost think about every person that you read their tomb. So I don't know. I think they get a little bit of credit. I don't know. You see couples. Sometimes you'll see a child's tomb. It's like, and sometimes stuff from the Civil War and Revolutionary. Like you see some really old, fascinating stuff. Think about the people that actually walked here before us. User says, ever represent anyone with narcolepsy or idiopathic hypersomnia? For sure. Have you, Shanna?
Yeah.
Yeah. You got to get your proofs, but it's doable. And God bless you if you got that. You want to talk about absenteeism interfering with being on task. You just fall asleep sitting up. Oh, Mr. Pet Mom is clarifying that he got his stuff after we talked. Well, I hope I gave you good advice. But if it was being sent to you anyway because you contacted your congressman before that, I will take that as well. I'm just very glad you got paid. Rocha says, can SSA require applicants to take applications like SSRIs? Oh, take medications. Did I say applications? SSA doesn't require you to do anything. You could just not treat. They're just not going to award you. I think your question more to the point is, will I be denied if I don't take medications like SSRIs or antipsychotics to qualify? Not necessarily. I think you have to really put in the record why you don't, and it can't just be because I don't feel like it. I mean, if you're psychotic and you wouldn't be psychotic, but for the fact that you don't take psychotic medications, guess what? You're you know, and I'm not saying you, I'm not saying you're doing this. You're opting to the side effects of the thing to you are worth it to be psychotic and not be able to work and self-sustain and take care of family. So sometimes people, you know, you have to present a persuasive reason as to why. And it can't just be like, well, I don't believe in putting anything synthetic in my body. Well, guess what? We don't, as I say, we don't believe in paying someone disability funds who can actually prevent their disability, but choose not to. You're going to have to really do your, and that's this other question. Can aids be paid to Medicaid without consent? I don't think so. I don't think you can be medicated without your consent unless you are perhaps a person who is now under like a conservatorship or guardianship because you lack the capacity. So if you've been found to, you know, and that would be, I think, a judicial hearing. That would be something in state court that someone has to fight for that, you know. Otherwise, I'm pretty sure you retain the right to pick and choose your own medical treatment. No one can force you. They don't have to give you benefits if you don't care to treat, but they hold you down and force you down. Unless, of course, again, it's that other situation. KTA, I keep saying that wrong. Does a disabled person have to be in crutches or canes in the eyes of the SSA? No, very few of mine are, and they all won. What do you say, Shana?
That, you know, sometimes that helps if you need that.
If you need them, then by all means. But that's not the only way to prove you can't. Yeah, you can't work a full-time job on a sustained basis. Jen says, I would love to see the answers for Shiloh's function report questions. Those are way above in the beginning. I've watched the playlist on the mental health RFC, done a lot of research, but still not sure. Okay, so I think what you're saying is, because I haven't even read all the questions yet, Jen, I think what I'll do is maybe I'll read them afterwards and I'll do a video and address them. Will that work, Shiloh? Only because look at the time. My throat is raw as I'll get out. And poor Shana's like, I just said 2 hours. So I never want to leave a question unanswered. But
no,
I
didn't have nowhere else to be, so you're good.
Yeah. My concern, Shiloh, was that, and I love the fact that you put them in early. I do. But I couldn't do them all, or else I'm making people who were here on time wait an hour to get, you know, I just didn't think that was fair. Should I say the word equitable? Which is really one of my least favorite words, but I'll use it for fun. Michael Ruth says he gets $1,882 for SSD. Yeah. I think that's better than that's like average right now, Michael. It's not higher than average, lower average, and it's going to be tight to live on. And, you know, I always say to people, first of all, move to if you're in a high end area, expensive state or whatever. I would like to see a sliding scale Medicaid for that. Now they say the marketplace can do that, but I don't know. I don't follow the marketplace. You know, it would be like well, and if you have a very expensive conditions, obviously that's the marketplace probably isn't going to cover half that stuff if it's a cheap policy. That's what I would like to see a sliding scale thing for people exactly in your position, Michael. I'm not really concerned about the SNAP and the rent because, you know, we can, you know, I had roommates back in the day to keep my rent down. Other people can do that too. That's if they're paying rent or whatever. I don't have an answer for you, but I could see definitely the pain of the health insurance. Let's say you had Medicare though, Michael. So you have Medicare, 82, let's say it's down to $1,600 after you pay for your Medicare. Do you think it's appropriate? You have health insurance, that SNAP would go away? Like, are you thinking you can't afford to feed yourself and pay rent maybe with a shared apartment with somebody or, you know, I mean, I shared a house with, there were 8 of us girls in there. We each shared a bedroom, you know, when the talk gets going. But so I'm wondering what your perception is like. I don't know. What do you think, Shanna? I mean, this is just like a opinion thing almost like, 1,600. If you're not, I mean, you could go get a little job if you're able. You got Medicare. SNAP says no. That's too much. You know, like you could buy your own food. I mean, I once fed a family of 4 on $100 a week. So, and I did it. It was a challenge actually. I was trying to desperately save money during leaner days, and you know, it was for family for $100. $400. So each person basically was eating $100 a month. You don't necessarily eat the best stuff. I think I did a lot of like whole wheat pasta, trying to keep it a little bit healthier. You know, when we made the pasta, we put less meat in it. We're like huge meat eaters, my husband and I. Like we can eat a big steak. I mean, my appetite's not like it used to be, but That was historically. Technically, I was probably eating far more protein than would be in the guidelines or whatever. So I'm just saying, like, that steak could have made probably 7 meals of protein. You know what I mean? If I didn't eat that all, but I don't know. I mean, I do think there's got to be a limit. I don't know what it is, like for SNAP, what's reasonable. I just know that we have to be creative with our bills, even like our cost of living these days is so much higher than it used to be. I mean, a phone used to cost $8, which is maybe now $16 when I was way younger. And it was like, as long as you didn't do it, out of area calls, young people don't even know what that means because now we have cell phones. But I pay $100 a month for now a cell phone because it comes with all the extras, the bells and whistles, the smart stuff. I can look at YouTube on there, but that's an expense. That's a cost that didn't exist, and my bill could be 16. Do you know what I mean? So our standard of living with all these fun things, Netflixes that we tack onto our cable, it really puts a big ding in the bank. And sometimes I think we have to start cutting out that stuff so we know we can afford on what we have, and not just people that are on SSD. Thoughts, Shana?
They don't make it easy for anybody, no matter how much your check is.
Yeah, it's an interesting question. How to prove this is user? Hello, user. How to prove if one sleeps 16 plus hours a day, sleeps like dead, nods off 20 times per hour. That's when you're not sleeping, right? And can't do anything on a schedule. Woo. Well, are you the one that asked about narcolepsy? Wow, that's excessive. Would we all agree? I assume you have doctors and they would be seeing you nod off in your appointments. Get all this stuff documented. You need to get that treatment. What do you think, Shana?
Yeah, you just have to go to the doctor's appointments and make sure you're letting them know and being vocal about the issues you're having, and hope they put it in the paperwork.
Every time. Keep a sleep schedule. I would keep a journal on that. That will be helpful later. And every few months you can give it to your doctor so he sees that 7 days a week you slept for 16 to 20 hours a day. That's a serious impairment. That's major, major. If you can prove that, you could be 20 years old and get SSD. I mean, that you don't have to have crippled hips or anything like that, or crutches or anything, that's really significant. Getting your proofs, objective proofs. They should be able to do some neurological tests with like sleep studies to learn that. If you haven't had those, I would definitely get those. Go to town on this because that is clear. That is so clearly disabling from every single full-time 8-hour day job. I mean, but you got to get the proofs. Jenny says, thank you both so much. Happy Easter. I think she tried to put in a little picture there, but it says face fuchsia flower shape, so it didn't work, but maybe it shows up later, Anyway, you too, Jen. Happy Easter. Happy Easter to everybody. I gotta color my eggs. I gotta get my focus my mojo to the right place where it should be for the season, for sure. I gotta slow it down a little bit. I was listening to a speaker the other day about being too rushy around doing everything, having too much in one schedule. I know I do that. Now I do know I'm very spiritual these days, and I do certain things every day, but I also probably blow off things I shouldn't, like including like paying attention better when my family's speaking to me, like when I'm at my computer, because I'll be like, I can't do this and hear you say, So sometimes I gotta like maybe carve out a little more time. So I don't know, but that's part of what Easter will help me focus on a little bit. Joel says, happy Easter. Thanks for your time and expertise. You too. Gregory Petty says, happy Easter, ladies. Thank you for all the information. Michael Ruth says, I just feel the state shouldn't take a cost of, yeah, I understand. Do they take away, Michael, all of your SNAP and all of this and all that? Or did they just reduce it by the amount of COLA? I forget what you said. Do you remember what he said?
I think they took it because of the COLA, that's what he said.
Oh, your COLA oh, that's a whole nother thing. Are you saying you had it with your benefits, Michael? You got COLA, your benefits went up teeny tiny bit because of COLA, and now you hit a hard barrier with, was it Massachusetts assistance with SNAP and all that and Medicaid? You hit the hard thing because of COLA, and they don't enjoy a COLA like that? That's crazy. See, they should just do an adjustment. You pay the COLA, we don't cut you out. Like, how about your COLA goes to that? You know what I mean? Like, that would be the sliding scale. Yeah. See, our legislators, they're dumb as rocks. And they're all, I'm not going to say all, but it seems like there's just so much greed. Either side of the fence, people playing games, like how about what's common sense and logical and works math-wise? If Michael's income went up by $20 and now you're taking away $800 worth of benefits, that because of the $20, that does not make sense. You know, it should be, all right, Michael, you got to give us $20. You know what I mean? And then you know what I mean? Like a sliding scale. Anyway, that's my big ass opinion on it. Pat Pint says, Happy Easter, and thank you, both of you. Yeah, Michael Ruth also says, cost of living increase into account. They should take it into account. They should adjust their, I mean, yeah, they should adjust their qualifying limits as well. Now, I will agree with that because SSI, well, that adjusts with COLA. And I don't know why state benefits wouldn't also recognize that COLA is inflation's impact and therefore it should adjust. But in the SSI field, what they never adjusted, and you guys know I witch about this all the time, the resource limit that a SSI person can save has been $2,000 since the 80s. As if $2,000 in the 80s is the same as what it is now. Ridiculous. I really hope they change that. There's some things that people are pushing for that I think they're asking for a mile when they should be asking for a reasonable inch. But that's not one of them. That one should definitely be changed. It's pathetic. What was some of the things that they I mean, some proposals are outlandish. Some say they shouldn't have a limit on savings. Really? So a guy with $500,000 in the bank can collect SSI that we all pay for when we work, and we can't even make savings ourselves, but you can have 500,000 and we still have to pay you. So I do think there's got to be a limit. I definitely think $2,000 is not enough. I'd be game for the 10,000 actually. And that's higher than what COLA would have had it. However, because I think I did the math. I'm a math person. However, the COLA never actually reflects the true. Is it cold in here for you? The COLA never actually reflects the true inflation. It doesn't use the basket of goods appropriately. It's not properly weighted. So I don't think the COLA is good enough to represent what really the cost of living, the index that they use it on, that they make the COLA from. So that's why I'm like, yeah, let's say with a proper COLA, it would have been 6,000. I'm still game for the 10,000 SSI movement too, because
I think they definitely need to change that.
Yeah, for sure. All right. So you didn't get rid of the SNAP. They just deducted the amount of SNAP by the COLA. I kind of get that. That I kind of understand, Michael. But the medical tomorrow is hold on a second, guys. I just gotta turn off this fan because I think my little girl here is freezing. I hope that's it. Is that shutting down? We'll find out. Sorry, Tasha. I was gonna say Shiloh. That's because we have a Shiloh dog visiting. And there's a Shiloh that was watching. Getting rid of the medical just means you can't even get treatment because no one can afford treatment plus living on $1,800, right? Like I get the COLA. That would be the sliding scale I'm talking about, Michael. But the kicking off the state medical doesn't. That is so detrimental. And what do you think, Shana? Am I seeing that right?
It don't make sense why they would adjust one and not the other.
Yeah, I mean medical.
I mean, if you would, in most cases, if you qualify for one, you do qualify for the other. So it's weird that they did it that way.
Yeah, it is weird. The rules are just la rocho. Well, you said you're mentioning antipsychotics, and those are for, and I'm not talking like Norman Bates. Antipsychotics are for psychotic symptoms. That's all. Good. I'm at the last one. We might not go down as not having finished. Howdy. Sorry, I'm late to the party. Hi, Jeffrey Taylor. Yes, you are. And we are about to kick on out of here. There was Shana Justice here all afternoon. Jeffrey, to me. All right. So the one thing I just want to qualify them for Jen and for Shiloh. I'm going to do those questions. I'm going to find them and I'm going to do a video on them. In fact, if you wanted to join me on those, Shanna, we could do a pre-recorded and get them answers. That's something we could do. Shanna and I have been talking about, collaborating on a couple of pre-recordeds. We're like, well, what should we talk about? That might be the way we could get our feet wet. Does that sound good? All right, kiddo. It was good to see you, Shanna. Do you want to stay on a minute after I close this down? I think I could still see you. Everybody, have a great week. Have a great weekend. Don't forget to come to the 12 o'clock dailies. And I hope to see you next week at 1 p.m. Eastern Standard Time for our weekly live stream. And I'm sure, hopefully, Shanna will be back. Any questions you have in the meantime, you can post them under any video. I check them all. I do get a little bit behind at times. It's not my first priority of my workday, but I usually do get to them, usually within a week. And I will either respond right there. If I don't respond, it's probably because I might be able to do a video, in which case I will share it to you first as an unlisted. And then when you've had a day or two to check your notifications and get it, I will later make it public or put it on the list of the publics. It'll probably go to members first because that's what everything does. It gets backed up as it gets queued for being one of the 12 o'clock dailies because I don't like to put more than one out on a day. So if I have more than one, they're going to be in a queue. All right. I will talk to you guys later. Dimple, you too. Happy Easter, everybody. Be well and be safe. And I will see you guys soon. Bye-bye now.